We are going to get started with our presentation. We are now live on the web as well. I want to welcome everybody. I'm Jerry Janzer, the CEO here at Reinhart Berner Van Duren, and welcome all of you to our firm. We're pleased that all of you were able to join us, not only those of you here in Milwaukee, but those who are listening in through the internet. I see many clients and friends and friendly faces in the audience here in Milwaukee, but for those of you who are not familiar with the firm, either here or on the internet, I want to speak briefly about our firm to give you a little background if you're not familiar with us. We are the third largest law firm in Wisconsin and one of the oldest, being founded in 1894. We're a full-service firm with over 200 lawyers practicing in 7 locations throughout the country. We have 3 locations here in Wisconsin, in Milwaukee, Madison, and Waukesha. We have 2 locations in Illinois, Chicago, and Rockford. And then we have offices in Phoenix, Arizona, and Denver, Colorado. We have one of the leading healthcare groups in the Midwest, and you will meet some of those individuals are in the healthcare group today and part of this presentation. When we decided to put on this presentation, as everyone in this room certainly is well aware, the Affordable Care Act is one of the most complicated and controversial pieces of legislation in the last 50 years. In addition to those aspects, it is also one of the most significantly impactful pieces of litigation affecting not only the healthcare industry, but virtually every employer in the United States and, frankly, every family and individual in the United States. And certainly we're winding our way through it here as a firm and advising our clients. We hope that today's presentation will help you understand it a little better and help you in your planning in whatever your respective field is. At this time, I'm going to turn over the presentation to the chair of our healthcare group, Tracy Klein.
Good morning and welcome everybody, and I wanted to just call out Rob Heath in the back of the room, who will be providing closing remarks in the questions and answers portion of the afternoon program. We at Reinhart are very, very pleased to be putting on this presentation and happy you could be a part of it. And you know, this is intended to be sort of a full day of learning jammed into probably 3 hours here. It's supposed to be a conversation, not just a lecture. We will have points in the day for conversation, and hope you that. We have a super panel today. 4 out of the 5 are here at this point. Let me start by introducing Gail Olson, who is a shareholder in the firm's employee benefit practice. And she serves a wide range of business clients, some of them small private concerns, others national corporations. And Gail advises our clients on a wide range of benefit design issues, but specifically and has special expertise in the area of healthcare benefit design. And she partners with our healthcare department to design collaborative and innovative solutions for providers and employers. She's both practical and very highly technical competent. So please welcome Gail Olson. Second, I'd like to introduce Stacy Conrad, and Stacy is the president of Conrad and Conrad Consulting. She's a healthcare consultant who's spent the last 10 years specializing in healthcare delivery impact on the commercial market. She works tirelessly to elevate the conversation in carrier and provider conversations, to push the parties to go beyond basic contracting, to develop partnerships and truly mutually beneficial outcomes that enhance quality and provide cost efficiencies. So I think it's a very cool thing to do. And she is currently involved with the creation of the Aurora Healthcare Accountable Care Organization, which is really a fabulous development. So we're very pleased to have Stacy with us today. Next to Stacy's left is Jerry Fry, and Jerry Fry is the president of Benefit Services Group. He is the owner and founder. Founded the company in 1987. BSG and Jerry Fry have a national reputation in providing consulting to healthcare systems all over the country, and especially in Wisconsin and Illinois. He has unique and creative insight to the most sophisticated problems facing both employers and healthcare systems. He's widely regarded as an innovator and thought leader, and I deal with him. He's a personal friend. He's super smart. And the other part of Jerry that you need to know is he's worked in healthcare and benefits consulting for going on 30 years, so he literally knows everybody in the industry, both from a provider, employer, and insurer perspective. So he's an extremely unique a friend and colleague to know. He's an expert on this provider-employer strategic initiative. So thank you, Jerry, for being here today, and we'd like to welcome you. And Dan Schwartzer from the OCI will be joining us later. Kevin Moore is in attendance. Kevin is also a friend. He was appointed by Governor Scott Walker to serve as Executive Assistant to the Department of Health Services. For those of you who don't know, that's the agency responsible for Medicaid and long-term care services. It also operates 4 mental health facilities and regulates the state's hospitals and coordinates the public health response for the state of Wisconsin. He was previously the policy director for the Office of the Governor Direct when it was transition mode, and was an advisor to Kitty Rhodes, who's the Deputy Secretary of the Department of Health Services. I view him as the consigliere and the loyal insider, as we were joking before. The most important thing you need to know about Kevin Moore, however, is that his mother happens to be the governor scheduler. So she's an extremely important position. So Kevin and I frequently talk on health-related policy issues, and I can tell you very bright and very insightful, and we are very pleased to have him here today. So we're not going to leave. We acknowledge and agree we are not going to leave knowing everything. We're going to try to take this 2,000-page complex piece of legislation, and what we're going to try to do today is set up a framework where you can see the playing field, just much as a center mid in soccer sees the playing field. Because when you start talking to people, people know a piece of it, but they don't necessarily know the entire field, and in fact, I think that's unknowable. It's kind of like the theory of relativity. But what we do know, what we can do, is take select pieces of it and break it down and try to make order out of the chaos. And I will start off by setting the table. And first of all, I'm going to say that a lot of people thought it wouldn't come to pass. It was enacted into law on March of 2010, and the Republicans campaigned for its repeal as part of the presidential election. As you all know, President Obama was reelected and answered that question. And as you probably all know, 26 states, including and also the National Federation of Independent Businesses, brought suit. They challenged key provisions of the Affordable Care Act, including the individual mandate and the Medicaid expansion, and essentially they lost. The U.S. Court of Appeals issued its decision on June 28th of this year, and we all knew it would be controversial. I mean, we knew no one was going to, that all parties would not be satisfied with that decision, and we knew it was complex. But we didn't know, what we didn't know in April or May is exactly how convoluted the decision really was going to be and how hard it was going to be to understand. We got a whiff of it, those of us who attended the American Health Lawyers Association on Monday, which was the 25th of June. We were sitting in a meeting, and a person who I highly respect, Julie Barnes from the Bipartisan Institute in Washington, D.C., stood up and she said, I think that the individual mandate is going to be upheld. And everybody's, oh, no, it's not going to be upheld. Well, she said, I have a staffer who was at the Supreme Court when they issued the immigration decision. And she said it took them a very long time to get back to the office, and everyone was trying to figure out where were they. And what they said is it took so long for Justice Scalia to read his dissent, and it was so clear he was angry that the announcement of that decision, which was sort of the decision before the decision, was a signal to everyone involved that it was going to be different than what we expected. And I want to just say as a lawyer, the word anger, maybe not at the state level, but the word anger and Supreme Court justices is not usually used in the same sentence. You have temperament of these individuals is beyond reproach, and so we listened. Our healthcare department huddled literally around a phone. I was out of the office huddling around my cell phone on June 28th. And that was an amazing moment because you had protesters, people screaming. You could hear it over the screaming, in support of both sides of the outcome. And as the syllabus was read, you will remember that the news reports came out that the individual mandate had been overturned. And that was, according to one of my friends in the law business, read on, my friend. The syllabus announced part of the decision, and as they were reading through it, they got to the component where it was upheld. So anyway, so it was a remarkable day, and it was a remarkable moment for our country. The majority opinion was delivered by Chief Justice Roberts, and I have these people up. They're the only 9 people in the country who've actually read the Affordable Care Act from start to finish, I believe. And I found the case extremely interesting. If you ever really want to understand the Affordable Care Act, read the decision. It took me 6 hours of careful study. I found it fascinating. I can tell you my husband did not when I regaled him with different parts of it. But you've got brilliant jurists who were jousting on key principles of constitutional law. And they agreed on very little. They agreed on very little. But what they did agree on is one central component, and that is that the ACA is a regulatory scheme to provide universal coverage. Now, there are health care reform aspects, and there are insurance reform aspects. It's very clear. There's a lot of reform in that law. It affects all of us, as Jerry noted. However, one thing the justices agree on, and I agree with them on this, it is a scheme for universal coverage, first and foremost. So the law contains financing mechanisms, and there's a driving point in it that says that health care delivered in this country is wasteful, and that it needs to be reformed, and so that more people can be covered and the funding will be available to provide this universal coverage. So there's healthcare delivery reforms that are ACOs, medical homes, bundled payments, readmission penalties, and some of that we're going to touch on this morning with Stacy and Jerry's remarks. But what you have to understand about the Affordable Care Act is at its heart, it's a restructure of the social contract as it relates to health care. Universal coverage is not delivered through a single payer. They had that choice. They didn't have the votes for that. So that was not the mechanism for universal coverage. What it was is a cobbled together approach. And what you have to understand about the Affordable Care Act is it cobbles together coverage in a system that already had Medicaid, already had private insurance, and already had Medicare. So there were gaps. And what the Affordable Care Act at its heart sought to do is to close those gaps. Those gaps before the passage of the Act were filled in large measure in this country by charity care offered by nonprofit healthcare systems. Now there were horror stories. John Q., the movie with Denzel Washington, where he tries to get the transplant for his son and he can't get the transplant. Ultimately, he takes the whole hospital hostage, and he's going to kill himself to provide the heart. And lo and behold, donor arrives at the last minute. There were gaps, but largely covered by charity care policies of nonprofit hospitals. So what we're trying to do here is cover more lives. So it's 2 principal things to get the lives covered. First is a Medicaid expansion. And before the ACA, Medicaid was a federal state partnership. It covered low-income children, their parents, pregnant women. It did not cover childless adults. Key component, did not cover childless adults except with respect to individuals with disabilities and some indigent elderly. So for the large segment of the population, Medicaid was not an entitlement program. It was much more limited. The other thing that you need to know is that the law contains something called the individual mandate. Now, the liberal Supreme Court justices call this the shared responsibility payment. But it's a penalty. It's calculated as a percentage of income, and it has a ceiling and a floor. So in 2016, the floor is $695, and it's never more than 25% of your income or 60% of the premium cost. And it's enforced by the IRS. It collected as a tax, but it's not subject to criminal prosecution. So there you have it. Those are the 2 key provisions that were challenged. And by the way, the 11th Circuit, which was the Florida case, went the other way than the Supreme Court on both of these. So this was the scorecard. And I put this up just to show that there is no order on this chaos. please note the dissenting justices did not agree with Chief Justice Roberts on any aspect of his opinion, period. They didn't join it, and they didn't even join it on the first issue, which was the Anti-Injunction Act barring the suit. They agreed with him, but they did not join his opinion. And basically, this was the result. Did the Anti-Injunction Act bar the action? No. Was the individual mandate constitutional? Yes. Was the Medicaid expansion constitutional? No. But only to the extent, it was only unconstitutional to the extent it threatened the loss of existing funding. So again, the question before the court was the constitutionality of the individual mandate. And for a while, I loved, one part of this whole debate was I loved the fact for probably 3 to 6 months, the entire country was talking about the Commerce Clause and the constitutionality of the Affordable Care Act, and we were talking about things like Wickard and Filburn and the guy who was making, using wheat for his home consumption, and the women who were growing marijuana in California and using it for their home consumption. Those were the cases that underlined through the Commerce Clause analysis. But ultimately, that wasn't the way the court went. So the Commerce Clause was the argument, and in a 5-4 decision, the individual mandate was not upheld under the Commerce Clause. And this was the first kind of perspective on this, and the case reads like a holograph. The first perspective on it was, hey, healthcare is certainly interstate commerce, and certainly because hospitals are big business and they buy and sell goods across state line. Remember the public accommodations and so the civil rights movement, and the fact that individuals, diners, and the South, were viewed to be subject to federal jurisdiction under the Commerce Clause. So the whole industry said, well, of course, healthcare is subject to regulation under the Commerce Clause, but the federal government, made the argument. The government made the argument it was necessary. The individual mandate was necessary as part of a scheme to regulate health insurance and health care, and the 5 conservative justices said no. And the decision hangs on sort of their perception that this was a forced purchase of a product. And they said basically, we can't allow the Congress to stand up an economy. This is a free market. And so what you're doing in this act is stimulating demand for a product. It's unprecedented. We'd never used the Commerce Clause to stimulate demand for a product. And the whole broccoli thing where everybody thought, well, are you going to be required to eat broccoli? It wasn't really a question of being required to eat broccoli. It was a question, what the Chief Justice was saying is, look, if you acknowledge that people do not eat balanced diets, that leads to obesity, and that leads to cost shifting. The question is whether the government can require you to buy broccoli. That was his quote. And so the answer was no. The conservative justices said, no, you cannot require people to buy product. So then they took a look at it from a different direction, and they said, okay. The government said, look, the individual mandate is an integral part of the regulation of health insurance. And something you have to know about our law is that basically the question of whether or not the regulation of insurance is interstate commerce is absolutely a settled matter. So nobody disputed that the Congress has the ability to regulate insurance. What they said is, in this case, is whether the individual mandate was necessary and proper to that insurance regulation in this context. And the conservative justices said that no, this was unprecedented and there was no limiting principle, and this was an exception that followed the rule. And so they said, no, it is not. If the issue is the insurance regulation, the fact that there is an individual mandate is not necessary and proper to that insurance regulation. So ultimately, it gets upheld, and this is where the Chief Justice flips. In the alternative, in an argument that nobody thought would prevail, the government contended that the individual mandate was an exercise of Congress's legitimate taxing power. And interesting, I saw George Katsas, who was the attorney who represented the National Federation of Independent Business, speak, and he was debating a Northwestern law professor. And it was 2 days before the decision came out, and they both agreed that if it had been enacted as a tax, it would have been unquestionably constitutional. because Congress has a very broad taxing power, i.e. Social Security. The anticipation was that the court wouldn't go this direction. There was nothing in their remarks that suggested that the court would take it on this issue. So ultimately, the Supreme Court does say, look, it can be upheld as a tax. And that was largely on Chief Justice Roberts' decision to change his mind. So he says the only question here is whether the alternative reading, of the law as a tax is reasonable. And he says the constitutionality doesn't hinge on what Congress called it in enacting it. And that's where he gets himself into trouble with the conservatives. And we have Justice Scalia, who, again, seems angry. And you read the opinion, he says, we cannot rewrite a statute to make it what it isn't. And he says, we have never held, and he actually said, we have never, and then he said again, we have never held, twice, that any exaction imposed for a violation of a law is an exercise of Congress's taxing authority, even when the statute calls it a tax. So he admonishes the Chief Justice. And it's obvious when you read the decision that it was written, his dissent was written as a majority decision. And the reason you can tell is when you read the decision, you get to the end, it reads one way, and then there's ... And he says, basically, the court today decides to save a statute that the Congress did not write. And he really blasts the Chief Justice. So there you have it. And that's sort of the table setting that I think is really important to understand. So when all was said and done, the Patient Protection Act and Affordable Care Act of 2010 affects us all, as Jerry noted. The law has individual responsibilities. It has the health benefit exchanges that are required to be created. It has individual employer subsidies that are required. It establishes an essential health benefits package. It has insurance responsibilities. It has responsibilities in terms of benefit design, healthcare transformation, financing mechanisms, and employer responsibilities. And it's probably the most comprehensive law to be enacted in our lifetime. So with that, what I will do is turn it over to Gail Olson, who's going to talk about benefit design and employer responsibilities at the outset. Gail?
Good morning.
Good morning, Gail.
All right. We have a lot to cover in a very short period of time, so it's going to go a little bit at the speed of light. Okay. But employers are facing some major budgeting challenges for 2014, and you'll see a lot of press about, how you have to decide whether you're going to continue to offer coverage as of 2014, and that's not true. Okay, 2014 is simply the first date on which the exchanges are available. So if you as an employer decide to quit offering coverage, there are alternatives for your employees. At that date, there are less than viable alternatives, shall we say, except for those people who may qualify for the health insurance risk-sharing pools. So what employers have to look at is what are their plans going to cost them, okay? And at some point, I would expect a little further down the road, we may see some movement away from employer-based health care in this country, but that has yet to be seen. So there are three components to this budgeting challenge. The first is there are some new plan design mandates, although most of them have already gone into effect. There are some new fees and taxes that are starting in 2013. And then, of course, we have the infamous player pay penalties. Following these three pieces, I'm going to have a very short case study based on some of the things that I've seen in working with employers, and then a suggested very short action plan for employers to look at in evaluating these. So first we have the plan design mandates, and they break down by the type of plan you're talking about. For all plans, this means grandfathered, non-grandfathered, self-funded, and insured. No pre-existing condition limitations up to this point. That has been only for enrollees under age 19. Now the gloves come off, okay? There are no annual limits on essential benefits. We've been in a transition period where you could have an overall annual maximum. That goes away starting in 2014. Third, children have to be covered to age 26 regardless of their eligibility for other coverage. This was an out for self-funded or for grandfathered plans where you could say, child, if you have coverage through your own employer or through your spouse, you are not eligible for your parents' coverage. Now that goes away and they can adverse select against you to their heart's content. Then we get up to this maximum 90-day waiting period. Now they have published some guidance about this look back and stability periods, and that applies to both the penalties and to the minimum waiting period for people to get in, recognizing that there are some employees who have extreme fluctuations in their working hours, okay? So you can actually establish a period up to a year where you measure whether that person is meeting the average 30 hours per week, and then you have the stability period that typically can't be any shorter than your look back. So, for example, if you had a year look back period, then you would have to cover them for the stability period regardless of whether they continued actively work, okay? So it's a complete departure from what we have understood in the past, right? Today, healthcare eligibility is in real-time mode, okay? If you're there and you're actively working, you're covered. Once you go on like a leave of absence or whatever, typically your eligibility for coverage ceases. That would all change under this look-back stability period stuff. And then finally, as of November 20th, the agencies issued wellness incentive regulations, and this was actually something that was built into statute, but only for non-grandfathered plans, where they changed the incentive from 20% to 30%, and actually under these regulations they pushed it up to 50% for incentives that would result in the reduction of tobacco use. So this is actually good news, and it's applicable to all employers to develop wellness programs, because I think the recognition is you can tinker with the payment system all you want until you actually get to the core of the issue, which is the fact that, you know, we live on a terrible American diet and we don't move enough and all of those kinds of things. Until we fix that, costs are going to continue to rise. All newly grandfathered plans, and this non-grandfathered plans, this is something that I'm seeing each year as enrollment comes around. I have plans that were grandfathered that decide to give up their grandfathering status because it's just too expensive to maintain it, okay? And this is just a reminder that once you make that switch, these are things that non-grandfathered plans have already had to comply with. The patient protections, the preventive care, which is now going to include the contraception and sterilization provisions, which are so highly disputed right now, and the enhanced claims appeal procedures. All new and existing non-grandfathered plans, the new mandates for 2014 are clinical trial coverage. These are things that are typically excluded as experimental today. And nondiscrimination in healthcare providers that are acting within the scope of their licenses. No one's quite sure what this means yet. There's been no guidance published, but I can tell you that the chiropractors did the happy dance when they saw this in the statute. New in 2014 for new and existing non-grandfathered plans, but only in the individual and small group insurance market, okay? See how you have to keep slicing and dicing the groups that you put these people in? They have the essential health benefits at the metal level. So what this is telling you is that if you're not grandfathered, you have a choice as a small group to buy coverage on the exchange, or you can buy coverage outside the exchange if your state allows it. But in any event, you're going to have these metal levels, okay? You're also going to have these cost-sharing limitations, the one that's in the green. You're going to have guarantee issue and renewability, and you're going to have community rating, which is going to tend to make individual and small group coverage very expensive. Yes?
Small group is defined as 50.
Well, it depends, and that was one of the questions I was actually going to have for Dan this afternoon. It's currently 50, okay? The default under PPACA is 100, but the state could elect to keep it at 50. However, since we're not operating the exchange, I don't know if that's a decision that the state still has or if that's one that the feds have, and I'm not sure that we even know the answer to that. Maybe Dan would have some insight. I was recently on a panel with the president of United Healthcare of Wisconsin. She said, I hope people are prepared because we expect that in the small group market the premiums are going to go up an average of 30 to 50%. And in the individual market, they will double or triple as of 2014 because of these things. They can no longer medically underwrite. It's guarantee issue. The community rating means that the only thing that can differentiate on is tobacco use or up to a 3 times age band, okay, which today they're like 15 bands when you look at an age-rated group. So add it all together. Now the reason this piece is in green, this is actually some good news for you, is that in the statute it says as of 2014 all non-grandfathered group health plans, quote unquote, are subject to these limitations. And we thought that meant all group health plans that were non-grandfathered, which would have pulled in large plans whether they were insured or self-funded. In the regulations on essential health benefits that were just published, the agencies decided, no, even though it says group health plans, it really means group health plans in the individual and small group insurance market. So that means if you're a large employer or you're a self-funded employer, you're not going to be constrained by these cost-sharing limitations, which I think is good news. Then some things that are still to be decided. All insured group health plans will be subject to these non-discrimination rules. That was supposed to go into effect in 2011. The IRS realized that the guidance that they had was a little too squishy, so they're working on new guidance. Expectation is it'll be published maybe sometime in 2013. Our understanding is that there will be at least a 6-month window before plans would have to comply with this. But something that I see very commonly in the insured arena is that a lot of employers will tend to pay more for coverage for their executive managerial staff than they do for the rank and file, and that's one of the things that they will have to quit doing under those rules. And then finally, all large employers, those who have more than 200 employees, are going to be subject to automatic enrollment. We've been told that will be sometime after 2014. So the new fees and taxes that you have to take into account. First of all, you're going to have to take into account all of these different design changes that may affect your plan, and I'm assuming that the underwriters that you work with and your benefits consultants will have some ideas on that. But then you need to take into account the new fees and taxes. First of all, these are what I call the indirect medical fees. Starting in 2012, there was this fee that was imposed on the prescription drug makers, and then in 2014 they're adding a tax on medical devices. And of course, since these are charitable organizations, they wouldn't dare pass these taxes back onto the consumer, would they? The Patient-Centered Outcomes Research Institute fees is a tax that's going to be on insurers and on plan sponsors for self-funded plans. And this is to fund federal comparative effectiveness research. It starts at the end of 2000, it started at the end of 2012, okay? It is based on the average number of lives, or as some people call it, belly buttons. Okay, it's employees and dependents. For the first year, it's $1 per head on an average, and then after that, it's $2 per head, and then that gets indexed up. It's supposedly a temporary fee, goes from 2013 to 2018. The first payment, it's an annual payment, it will be due July 31st of 2012. And this has kind of a funny due date. It's like the July 31st after the end of the plan year. It's not a certain number of months. This is the one that I think is going to really upset some people. The temporary reinsurance fees are to support the high-risk influx into the individual insurance market. You have all these people who've never had coverage, okay, who haven't had anything taken care of for years. All of a sudden, they have no pre-existing condition limitations, no medical underwriting, no guarantee issue, they get on the market. This is to support the insurance carriers that are going to provide that individual coverage because they're kind of, you know, shooting darts in terms of figuring out what their premiums are going to be, okay? My guess is that they're going to guess high, all right? Which is why we've been told, you know, they're going to double or triple in cost. But this fee is going to be imposed on all insurers and on third-party administrators based on the number of members per month, okay, per member per month. And what they're saying per member per month means in this context, I always knew that as being per employee per month, but they're calling it, again, per belly button. It's going to be $5.25 per person covered by your plan per month. So a family of 4 is $5.25 times 4. If you have 1,000 people covered by your plan, That's $63,000 a year, for example. So this is a lot of money. Now, supposedly this is a temporary fee from 2014 to 2016. We'll see how temporary it remains. It's also supposed to drop as time goes on because the insurers should get better at measuring what the costs of the plans are. If you are an insured plan, you are going to be subject to the health insurance tax, affectionately known by people in the industry as the HIT. It's an annual fee that's on health insurance. Once again, being charitable organizations, they certainly wouldn't pass this back to their clients. And it starts out at $8 billion and goes up from there, and this one goes on forever. When you think about this, it seems a little bit backwards because it's going to disproportionately affect the individual and small group market. They are the ones that are insured, and yet they're the ones that are going to face this additional increased cost. Finally, something to keep in mind, that this isn't 2014, but certainly it's going to be looming ahead of you not too far into the future, is going to be this Cadillac tax. One of the reasons we were happy to hear about the agency's view on the cost-sharing fees is I had actuaries that were telling me they didn't think that employers would be able to meet these amounts if they were going to have those limitations on their cost-sharing, okay? What this basically means is that if you have a plan that's valued at over $10,200 for single or $27,500 for family, and there are some special rules for other groups on this, but if you're over that, any amount that's over that is subject to a 40% excise tax. So, now that I've made you all happy, how about these player pay penalties? And I think the point that I want to make before we get into this, it's not just are you deciding to offer coverage or not. There are some circumstances in which you cannot offer coverage and still have penalties, okay? The first issue is that it applies only to large employers, all right? But employer is evaluated on the control group basis. So if you are part of a group of organizations that share common ownership and common control, that's looked at as one big single employer, and you have to count all the people who are employed by that big group. So if you're not sure if you're in a control group or not, I would suggest you talk to the people who file the taxes for your firm. They're the most likely persons to know right off the bat. The second thing you need to know about this is that it has now decided that a full-time employee is somebody who works 30 hours a week, okay, which doesn't meet what we have traditionally thought of in this country. I have lots of plans that are self-funded that have 32 hours, 35 hours, 37 and a half hours, 40 hours a week as their threshold for eligibility. This is going to drop everything down to 30. You have to add together your full-time employees and your full-time equivalents. Your full-time equivalents are determined by taking your hours for your part-time employees for the month and dividing them by 120. There is some grassroots activity to try to get the agencies to move that up to 130, which more accurately reflects the number of hours if you're looking at 4.3 weeks in a month. And that may happen. But for now, it's 120. That's the way it reads in the statute. And no penalty applies unless at least one of the large employers' full-time employees, in other words, somebody who works 30, actually enrolls in a qualified health plan on the exchange and receives a subsidy. The important thing, I think, to remember about that is that you have some people at some fairly high income levels who are going to be eligible for subsidies because 400% of the federal poverty level in 2012 for a family of 4 is 92.2. Okay? I would imagine that there are a lot of families in this country that would fit into that category. There are two types of penalties. One is this no coverage penalty, and by the way, these are my terms. You won't see these, but I have to kind of distinguish between how they work. And that's the failure to offer any minimum essential coverage to any full-time employee. Minimum essential coverage is not the same thing as essential health benefits. Okay, you are not required to offer an essential health benefits package unless you are in the individual or small employer market. Okay. What you do have to worry about is any limitations you would put on essential health benefits. Minimum essential coverage is defined as just about anything, including employer coverage. Okay? The substandard coverage penalty means coverage that is offered is unaffordable or it's less than minimum value. We're going to go through what these things mean. Okay, for the no coverage penalty, at least one full-time employee who's ineligible for the coverage enrolls in a qualified health plan and receives a subsidy. The monthly fine is the applicable payment amount, is 1/12 of $2,000, which equals $166.67 a month, times the number of full-time employees minus 30. Where they came up with the minus 30, I don't know, but they give you a break on your first 30 people. And this penalty is non-deductible to the employer. So if you decided you were dropping coverage entirely, you add up the number of people you have that work more than 30 hours a week on an average, you multiply that by 2,000, that's going to tell you what your annual penalty would be. Substandard coverage. Okay, coverage is substandard if it's either unaffordable or less than minimum value. The statute actually says that it's unaffordable if it costs more than 9.5% of the employee's household income for all coverage. And of course, employers don't have access to what an employee's household income is. So the IRS came up with a safe harbor for at least the first couple of years that says you measure this by saying, is it less than 9.5% of the person's W-2 wages for single coverage for the year? Okay? If you make it past that, you don't pay a penalty. Now, it could be that it exceeds 9.5% for the whole family coverage, and then the person would be eligible for a subsidy. So you kind of have this bifurcated thing going on. That's why I have my doubts whether it's going to last more than a couple of years, because I think the government on all this penalty money, which was there to help subsidize the cost of offering this. Minimum value means the benefits are at least 60% of cost, so you design your plan if you're paying at least 60%, across the board, you're going to meet this. I think most employers are going to have more trouble with this affordability prong than they are with the minimum value prong. Okay, when you look at the substandard coverage penalty, your fine is 1/12 of $3,000, which is $250 a month, times the number of FTEs for whom coverage is offered, that is unaffordable and or of minimum value, and who enroll in the qualified health plan and who get a subsidy, okay? And then it's capped at however much you would pay by not providing any coverage at all. So when we look at this case study, okay, and this is kind of an amalgam of groups that I've looked at, I had one that had about 300 employees in several different facilities. These were not highly paid people. They were making between $8 and $16 per hour. 200 of those employees worked 40 hours a week. They had 50 people who were in the 30 to 40 hours a week and 50 who were below 30 hours a week. At a self-funded health plan, they had a 40-hour per week eligibility threshold. Their employees are paying about 1/3 of the cost of coverage, which is pretty normal in this area. Their single coverage contribution was $100 per pay period. They had 26 pay periods, so it was $2,600 a year. Well, their no coverage penalty, okay, they had 50 people who were in the 30 to 40 hours a week who aren't eligible for coverage, all right, as the plan stands. If they don't change that, they have to pay a penalty for everybody. This is what they call the sledgehammer penalty, all right, and that would be $440,000 for the group, even though you might be offering coverage to everybody over 40 hours a week. So this would be on top of whatever you were offering. Okay, it really makes for a great incentive to change your eligibility to 30 hours a week. The substandard coverage penalty, if you take the lowest paid person, say $8 times 30 hours times 52 weeks, they're making $12,480 annually. You take the $2,600 that they're paying for single coverage and divide it by that, they're paying 20.8% of their W-2 comp, okay? So it's going to be unaffordable. And actually, we did this on the highest paid employee, and it was still unaffordable. So one of the ways, there are a number of things that you can look at doing. One of the ways you can work with this is to increase the amount that you're covering or paying for single coverage and decrease the amount you're paying for dependent coverage. And actually on this particular group that I was looking at, if we paid like if the employee was dropped to 15% instead of 1/3, and they had to pay 50% for just the dependent portion. It actually came out so that we met these criteria. It cost the employer about $40,000 more a year, but it actually came out fairly close in terms of what an employee with family coverage had. It was slightly increased, not dramatically increased. So I would suggest that's something that people should look at.
Yeah.
Yes. Yes. Since their single coverage was more than 9.5% for all, okay, their penalty would be $3,000 for each full-time employee who bought a qualified health plan on the exchange and received a subsidy. And so if we took and said, okay, just for an example, if 50 people did this, you would have a penalty of $150,000, which is non-deductible, and you're still paying 2/3 of the cost for everybody else. So it's a very unattractive financial picture. The action plan. Obtain estimates of the impact of the plan design mandates and indirect fees on your plan, which I think is a fairly simple thing to do. You calculate the impact of the direct fees on your plan. You determine if the employer play or pay penalties may apply to you. In other words, do you meet that 50 employee threshold or not? If you don't, you've got it made. The play or pay questions you have to ask is, first of all, are you part of a control group? So what's your universe of employees you look at? Are there any full-time employees who are not eligible for the plan? Because I think you need to fix that. Does your employee contribution satisfy your affordability requirements, that 9.5% number? And does the plan satisfy the minimum value standards? Okay? And I think we have some people who are going to be talking about other plan designs that will help take care of some of these issues, perhaps not in a direct fashion, but a more indirect fashion down the road. Thank you.
Okay. Hi. I'm going to talk about how this gets applied by real-world employers. And so we're going to talk about alignment. These are some examples up on the board of plans that are 60% actuarial value. That actuarial value is going to be a little different depending how you calculate it. But at the end of the day, if you take $1 million of standard distribution claims, hospital inpatient, outpatient, RX, medical, et cetera, it just means that the plan, by its provisions, will pay about 60% of the costs, and about 40% of the costs are going to be borne by the participants in that plan by virtue of the co-payments, deductibles, et cetera. So that's really what actuarial value means. And so you can see some examples of some plans here that all can meet that actuarial value. Obviously, if you limit the out-of-pocket, like it's saying for some of the smaller employers, to $2,000, $4,000, you have to go to plans that have like 90% coinsurance. In other words, the plan will only pay 10% on the first amount. I mean, you have to jam all that expense right up front, and it's pretty hard to get the 60% actuarial value in that case. I tell you that because this busy slide is really one I want to spend a little time on. This is real world. Essentially, the average employer plan contribution for single coverage, and that's really what we're talking about here, in this market, in the southeastern Wisconsin market, it's not very different in Illinois for those listening, is about $105 per month. And so the example we had earlier was about twice that. So this is a typical employer. And we started with a base of $16,755. You could take it down to $12,000. It wouldn't change the numbers along the side very much. And essentially what the law says is that 9.5% of that amount, that salary, is affordable. By definition, it's affordable. I don't think the employees would agree, but that means that if somebody's at $16,755, we can quote-unquote charge them $132.64 a month, and our plan is still affordable. What that means is, as long as I offer a 60% actuarial value plan that has at least that value, reaches that threshold, and I don't charge more than this, and I make everybody who has 90 days of service, meets all those FTE requirements, and it works more than 30 hours. As long as I do that, I can immunize my plan as an employer. And so I'm not subject to any penalties, those $3,000 penalties. First off, I'm not subject to the $2,000 penalty because I offer coverage. You can have multiple options. As long as one of your options meets this requirement, you've met the standard. Okay? So at the end of the day, an employer could choose to immunize your plan. Now that doesn't preclude a participant from going to the exchange. They can still do that, but they're not eligible for subsidies, and the employer is not subject to any penalties. Okay? So at the end of the day, this becomes an interesting design. So I was with an employer yesterday, has 2,700 eligible employees, but only has about 1,400 covered. So here's a case where they're spending about $10 million, but the employees pay close to 40%, so their net cost is $6 million. Okay, so they're spending a net of $6 million for their health care. But they have 2,700 eligible. If they terminate their plan, they'd have to pay the $2,000 less 30 people, but I'm not going to concern myself with that here, that minor credit. But they have to pay $2,000, so that's $5.4 million penalty. Now, they pay $6 million in their net cost. Admittedly, the plan cost is 10, but the employees are paying that $4 million. Okay, so they've got this $6 million expense, which is deductible. If this is a profit-making employer, they're going to get credit for that. They're not going to get credit for the $5.4 million penalty. In this case, because this was a for-profit employer who was making profits, so in their case, it would actually cost them money to terminate their plan. Now, if you have higher costs, this is an employer that has, tremendously reasonable costs. They're very, very aggressive at cost management, and so their gross costs are maybe 20% below market. If you have an employer that has $14,000 cost per employee kind of thing, then that thing turns against them, and there's an opportunity. But just keep in mind that the penalty is not tax-free after tax. And so if you're nonprofit, it doesn't matter. So I'm going to go back to this example again. You can see in this example that there's this premium at $55.85 on the top column there. It's called the estimated subsidy premium. Understand the object of that is that's the premium. It's a premium for anybody who is eligible for the subsidy. Okay, that's not the subsidized amount. That's the amount that a person who makes $16,755 would have to pay for coverage. Now, we talked about the metals earlier, and there are these four plans in the exchanges: 60% actuarial value, 70, 80, and 90. Everything on this page is a 70%, because only the 70% plan, the silver plan it's called, is the one that's eligible for subsidies. And I'm not going to get into whether the federal government can do subsidies or not, because that's another battle for another day. We're just going to assume that they have that right for this illustration. Okay, so at $55.85, there's another thing that happens, and only the federal government could do this. I have the 70% actuarial value plan that for somebody making $16,755 will actually get a 94% actuarial value on the right. And they do that because because of the income, they will artificially suppress the out-of-pocket. So the out-of-pocket can't exceed $1,963. So I have different levels of coverage under the 70% plan. So when I go to the exchange, federal or state for this discussion, I'm going to, based on my salary, I'm going to get subsidies on my premium, and I'm going to get subsidies on my out-of-pocket. And so as a result of that, there are really four levels of the 70% plan. And they're up there for you. They're 94, 87, 73, and 70. One of the things I want you to understand, though, and I don't think there is a good understanding of this in the marketplace, and that is, yes, people up to 4 times the federal poverty level are eligible for a subsidy, but the effective application of that subsidy doesn't apply to very many people. Look at this. If I look at this chart, at $105, even subsidized, when I get to $22,500 salary, the subsidized premium is greater than the current cost that the employer is charging. It's $118. And by then, the actuarial value drops to 73%. I will tell you the average actuarial value of the average PPL in Milwaukee is about 78%, 0.78. So the fact of the matter is that the average employer, large employer now, is providing higher benefits than the subsidized benefit at a lower cost. So there aren't a lot of people that are going to be attracted to this. Now, if you have a problem where you have a lot of people that you're not considering eligible today, what the employer has to do is either reconstitute those jobs, restructure them in a way that they have less people eligible, or what I see some employers deciding to do is they're going to offer a plan that's 60% actuarial value, and they're going to charge 9.5% of household income. So they're going to change it. And so what the federal government means as a minimum becomes a maximum, just like mental health mandates and all of that over the years, right? Mandate switch. And so you'll see some employers, especially in high turnover, low volume business, low paying business, you'll see some do that. Now, one strategy that can be employed is, depending upon your array, and for employers, we'll typically show how many people are in each of these classes, you can create a defective plan. Just choose to charge 10% contributions. Your plan is now defective by design. That means that anybody who is eligible for a subsidy can get a better deal on the exchange, can go there, and you'll pay $3,000 for each one of those people. But it may turn out, and we have a half a dozen examples, where that turns out to be a good strategy for an employer. Let the low paid leave. What you need to do is claim study and determine whether that's good, you're helping or hurting your risk pool. Okay? So that requires a little bit of work. But the fact of the matter is, while the front end says, of the law says, subsidies are up to 4 times the federal poverty level, at the end of the day, we don't see much effective application of the subsidies or attraction to the exchanges for most employers for anybody below about $22,000. For most employers, that cutoff is somewhere between $18,500 and $22,500, the effective cutoff where somebody's going to actually be attracted for those subsidies. Okay. I'm going to talk a little bit about what the insurers are facing and what you're likely to run into as a product if we send people to the exchanges. And what we have up here is the premium that these exchanges are going to have to offer, and in many cases, plans off the exchange, because it was alluded to earlier, but the state can require that the plans off the exchange follow the same underwriting rules as the plans on the exchange, which means there's no really point to having a private market much anymore. But there are some states taking that approach. And I'm going to talk about a couple of these, but there are a lot of reasons why this is not going to be very attractive. There's going to be a huge outcry when people actually see what this means, especially to the individual market and the under 50 market, the small group market. So this is an example. So we're looking at 2012 on the left-hand side, and I have, let's just assume, a 12% rate increase coming in. We have about 3%, 3.8%, that's the monetized value against the renewal for the typical employer in the small group and the individual market. That's the $5.25 per belly button fee. That's the dollar PCORI fee, and it's also the HIT, the health insurance tax fee. So you have those 3 fees that were referenced, and monetized out against a $400 PMPM, $400 per member per month kind of cost structure that works out to about 3.8%. That's going to hit everybody. Okay, it's an automatic. Now we get to the product. Well, because of community rating, which was talked about before, we have to rejigger how rates are done. So today, I can have rates based on male or female. Well, older males are lousy health risks vis-a-vis the commercial community. Younger females are higher health risks. Notice I didn't use the word lousy. But the fact of the matter is that those are the higher risks. So that's where our healthcare cost gets concentrated. We're not allowed to use gender anymore. And then age, right now, most carriers have somewhere between a 7-to-1 and 10-to-1 banding between their lowest and highest rates for the commercial market. That has to be compressed to 3-to-1. By its nature, everybody should be able to see that the narrow or the compression causes the older rates to have to come down and the younger rates to go up. In Wisconsin, that's not a very nice gift, because the fact of the matter is we're a little bit older than the country as a whole, in particular in our commercial market. And so as a result, the midpoint is not where you might think it is. The midpoint actually ends up where the median is, and that's way up towards the older side. So what happens is about 2/3 of all groups are going to face between 30 and 35% increase, and about 1/3 of the groups are going to see decreases around 1%. Okay, it's not a very good trade-off, but that's the deal. And because you're raising those lower rates up so much, that was the reason why they felt we have to have an individual mandate. If you don't bring in the people that you're purposely overcharging, why would they do it? Why should they come in? Especially with the Massachusetts experience, that I can be signed up as I'm being rolled into the emergency room. I don't need to buy coverage before then. And then they keep their coverage for the month or two it takes to clear the issue, and then they drop it. And so there's quite a bit of material in the literature about that. So the fact of the matter is that this is a block of business on the largest commercial carrier in the state, so I think everybody can figure out who that is. And their view is that it will be about an average of 116% increase in the individual market. There's another thing that's not talked about very much, but in healthcare reform, in the budgeting, there was a 7% credit taken to all healthcare because we're reforming it, for no other reason. Just because we passed this law, healthcare costs will go down 7%. It's right in the CBO's budgeting schedule. Now, you take $2.6 trillion and 7%, that means we evaporated $150 billion of healthcare. I can tell you, I work with providers and employers every day, and if somebody doesn't change their behavior, that healthcare bill doesn't go down. And so I think we have a bogey we have to deal with against the budget numbers that are there to begin with. But in addition, we have this issue that there's a fundamental misunderstanding about how markets work. If I buy for 1,000 people, I have a budget, and I make a decision around my network choices, my benefit design choices, etc., around that budget. When I take the same 1,000 people and I give them all an individual choice, the cost is about 18% higher. And it's because each family is going to choose the plan that's better for them. Well, people will say, well, I have 3 options under my group plan. Yeah, but when you take that 1,000-life group plan, the underlying rate for that group is set at an appropriate level, and the difference between the options in that group is the actuarial difference between those benefit levels. The rate level is right. What happens here is we blow up the rate levels for groups, and you actually move it out to this community rate, and so what happens is costs will go up 18 to 20%. That's why individual coverage has always been more expensive. There's this underlying cost to moving from wholesale to retail purchasing in healthcare, and it doesn't get discussed much. The health carriers know about it. It's hard to explain to the public because they want more choice, they want all these options, but the fact of the matter is there's a huge benefit to buying in pools, in groups. The small group market isn't quite as bad as the individual market. By the way, the other carrier, the other major carrier that has the second most business on individual says that their estimate is their block will go up 202%. This carrier is only 116. That's individual market, individual policies. And remember, when I go to the exchange, there aren't any group rates for groups that are larger than 50. It might be 100 if we have a federal exchange here, but there aren't any group rates. If you have a family of 6, you're going and you're buying 6 individual policies. Does everybody understand that? That's how it works. And so if my older people go there, even though the age banding is 3 to 1 in a group rate, we have a single rate for everybody. Every single person pays the same rate, right? That's not the case on the exchange. Every person pays the rate that's appropriate to their risk, even though the risk choices are different. The group thing is going to be about 25% in general. If you're an older group and you're really sick, you might get a decrease in cost because of community rating. If, on the other hand, you're a healthy group and you're young and you're doing a lot of wellness stuff, you're very likely to see a pretty healthy increase on an average of 25 to 35%. So, you're a carrier. You need to price for this thing. You need to understand the mechanism of what's going on the exchange. So now I've got to reprice all of this. I'm still competing against myself, arguably, in the private market where I may be able to price things differently, have different benefit levels, etc. So different rules. So I'm pricing against myself, remember. And then the issue is that there's this rate review. There's not been much discussion about this, but remember, anything above 10% calls for automatic rate review. By law, it is an unreasonable increase. Now, carriers don't get to print money. I know some people think they do, but they really don't. They're spending our money, okay? They're moving it around for us. So the fact of the matter is that they have to be very careful about where they set those rates. If they set them too high and their market share is too low, they're pretty sure they're going to get very, very bad risk. And there's some other risk-sharing mechanisms that haven't been talked about, and we don't have time to discuss in 20 minutes. But the state has the ability and will, in fact, put in risk-sharing mechanisms that will move risk from the self-insured to the fully insured side to help compensate people. So carriers could play the game and say, well, we're going to lower our price, take on lots of risk, and hope that the bad risks we get are going to be compensated through the risk-sharing mechanism. Now, those regulations aren't published, and that's an interesting business play. But you're not likely to do very well. Now, let's just say as a carrier you win, and let's just say it's really good. What happens? MLR, maximum minimum loss ratio, right? So if I actually start showing return, I have to turn around and give that money back because I have gouged the consumers. So you got to think about this from the employer, from the carrier standpoint. No pre-ex. People can come in whenever they want. They can leave when they want. They may or may not get subsidies. And by the way, that's another thing about the subsidy. If I get that subsidy based on household income, let's say I go to the exchange and the safe harbor for the employer is single pay, right? The employees pay. But at the end of the year, this is like withholding. At the end of the year, the IRS is going to actually still apply household income as a standard for what subsidy you as a family are entitled for. And so the actual cost of coverage, less the actual subsidy you're allowed, is then compared to what you actually paid. And so there are going to be a lot of people that are going to end up with tax deficits at the end of the year. What I find really interesting about this is there's no criminal enforcement mechanisms. So the IRS can't use any of its collection mechanisms to actually get the money back. So I think it's just, we're kidding. There's no mechanism to collect the money. But I just want you to know, people are going to be setting themselves up for all kinds of issues because that gets settled at the end of the year. So I kind of talked about this. We have all kinds of loss corridor projections, et cetera, and I really can't get into the mechanics of this, but this is very complicated between the employee and the exchange, and then you have the markets actually have these leveling mechanisms that apply. And if anybody wants more detail, just email our office. We'll be happy to send you white papers around any of these issues or talk with you. When we talk about the adjusted community rating, just want you to understand the only thing that things can be rated on is family structure, the actual benefit design, which has to follow the metal structure, the geography. We can have limited geographical differences within a state. Tobacco use, we can still hammer on tobacco use, and we were given more. Tobacco has really fallen out of favor in our culture, and we were given huge, huge levers for tobacco in the new wellness stuff. We can go 30 points on all the other stuff and another 20 on tobacco. So, I mean, it's a huge, huge difference between people who are playing the game and aren't. Interestingly enough, though, with community rating, that's the difference in what the employees can pay, but the employer bill is not going to change a lot, right? Because it's community rated. So the employer who does all these things and drives their employees to better health doesn't necessarily benefit in their cost structure as a result of those activities, at least not in health expenses. Arguably, their culture is better, they may have better operational costs, etc. The rates may not vary based on gender, health status, claims history, medical underwriting, group size, or industry. That means a group of 8 employees has to have the same discount and have the same cost structure as a group of 80 or 800 if we get back to 2017 and they lift the rules. So here's some of those fees again. We've talked about them before, but again, the estimated impact of the 3 fees put together, PCORI, the patient-centered research, the HIT, the health insurance tax, and the reinsurance tax, is about $16 to $17 PMPM monetized. So it'll hit all of you in different ways, and it'll be slightly different amounts and at different times, but the fact of the matter is that's going to be a load that's going to be kind of applied across the board. I also have a personal comment about PCORI. I just want you to think about this for a minute. The federal government's going to get into patient-centered effectiveness research. Effectiveness research means different things to different people. And until now, effectiveness is, I have a cardiac issue. What are the range of services that could be used to treat my cardiac issue? Let's choose the most efficient amongst those options. That's the kind of patient-centered research that typically we think about. That may not be what's in mind based on a lot of the literature. They could be talking about, should we pay for cardiac services at all against providing prenatal care over here? And so it's not patient-centered from the standpoint of you, what's best for you in your circumstance. Because this has been done in Oregon under their Medicaid program already. It's a much wider question about, is this efficient use of the resources of our community against health care expenses? And so just watch out for that slippery slope. Just want you to be aware of it. So the case for, how much time do I have? I don't want to go over. All right. The case for employee health. So for a lot of people, the exchange is really not an option. You need to do the research for your case. Every case really does look a little different when you apply all of this to a given fact set. But at the end of the day, there's a couple of truths about health care, and that is that there are these 4 quadrants that healthcare drivers fall into. There's the employee health, the employee behavior, the provider behaviors, and the employee or the employer behaviors. And if you think about it, most of us spend most of our time, consultants, employers alike, spend 85% of our time on the plan sponsor behaviors. How do we design the plan, deductibles, co-payments, eligibility, contributions? If you think about it, healthcare reform has taken most of those tools substantially out of your hands. We spend 85% of our time there, yet I will tell you, over decade-long studies, that's only 6% of the driver of cost. That explains why, in spite of all of the efforts, all of our best efforts, and all the money we save at every renewal, right? Everybody's sitting at the table, oh, we did all this good stuff to hold on costs. We're all paying, 3 times more than we did 20 years ago, and some of us a lot more than that. Systemic 8-10%, because those activities do not fundamentally address the drivers of cost. The drivers of cost come 70% out of the employee health bucket. They come 10% out of the employee behavior bucket, 14% out of the provider behavior bucket, and about 6% from the employer behavior. And I would submit to you that we do a really lousy job of getting to the 70%. Why in the world do we continue to spend so much time on the employer part? Well, that has to do with ROI. I can get the ROI on that 6%. I can yield almost all of that every 12 months. I can hit next year's budget. And so we concentrate there, but at the end of the day, we have to get to the employee health bucket. It's going to take 4 to 10 years to get the return there. And so if you're off the exchanges, which I think many larger employers will still be off the exchanges for at least the next 4 or 5 years till they're right and maybe do present an opportunity, you need to be able to manage your costs in a way that you stay below the Cadillac tax. 2/3 of the companies we test will exceed that Cadillac tax before 2020. 2/3 of the Wisconsin companies. I will just submit to you, you have to surrender, you're done. I can show you all kinds of illustrations, but you cannot stay in the business and pay Cadillac tax. It's a 40% non-deductible excise tax. Not only are your costs high, but that tax on top doesn't help anything. So that takes effect in 2018. That gives time for companies to get involved into the wellness game. The healthcare reform law has given you very powerful tools in the form of premium contribution incentives that can be used to try and drive towards that. But you have to get engaged now, and it can't be health fairs and stuff like that. It's going to have to be a health and productivity model. It can't be fun wellness. This has to be serious wellness, and it has to be integrated. Okay. The employee behavior bucket, a little tougher to get to too, but it's 2 to 4 years. And the provider bucket is 12 to 18 months. It's pretty quick. And I'm going to close with this last thing. And that is, what you need to do is get to a better network, better health, better savings. And I'm setting the stage for the next speaker, which is Stacy, and we both worked very close on the Aurora ACO, but this could work for any hospital system, any ACO, any place where they get serious about integrating the care. Integrated care costs between 6 and 8% less. It shows that way across the country. There's a lot lower set point on the price. And now, one thing that healthcare reform did that we haven't talked about is set up this mechanism called an accountable care organization. The accountable care organization puts pressure on the health systems to vertically integrate and take risk. Now, it was designed to do this on Medicare, and for a whole host of reasons, it's not taking off there. But most hospital systems and health systems have come to the conclusion, boy, this is a good strategy for our commercial business. Why? At the end of the day, it's not about build it and they will come anymore. Matter of fact, somebody just told me about the Elmhurst Hospital situation down in Chicago. They're dying on the vine. Built a brand new hospital, there's nobody coming. So at the end of the day, it really isn't that. The hospital business has changed to one of margin, like the rest of us. And so it's not a revenue model anymore. It really matters on the margin. Well, in this community, if I have $1 in billing as a hospital, I need 40 cents to operate. If I don't collect 40 cents of every, that's how screwed up the charge masters are. If I don't collect 40 cents out of every dollar I bill, I can't run the hospital. Medicare is paying 36 cents. Medicaid is paying 18 cents. So at the end of the day, my only margin comes out of the commercial market. So even if I give bigger discounts in the commercial market than I am now, it's still better than a Medicare or Medicaid. And I'm not talking about the quality of the people or any of that stuff. Just talking about sheer economics. And at the end of the day, there's $716 billion in Medicare cuts that are coming in a couple of weeks if we don't do something about that. And so essentially, the Congressional Budget Office's own estimate is that Medicare reimbursements will be dropping, and they could drop down to the Medicaid level. In this town, most of our hospitals between Medicare and Medicaid are somewhere near 50% of their patients are on one of those two programs. So they have to make it on the other half, and so it's about commercial patients. It's about payer mix, and as employers, we have this opportunity to buy in a different way. Not all cardiologists who are licensed do the same level of work. Just like not anybody in any business does the same level of work, there is a difference. The tools we have today are better than they were in the past. I would tell you, you have to aggressively go after the employee health issue, and you have to aggressively reassess how you're going to do your networks and deliver your plans. If you do those two things, we have a book of business of about 1.5 million people, about half in Wisconsin, half out, and the growth trend since 2002 is under 3%. It's possible to do it, but you have to break some eggs to make that omelet. You can't do what you've been doing. You have to do it differently. So at the end of the day, to stay in the game, if an employer is going to stay in the game, you have to have better information systems for much better decision support than you've been getting. You have to have better network selection. I can tell you that if I take any group of 100 specialists in any specialty, do them by efficiency and by quality, put them on a grid, take the bottom quarter out, I can cut 17% of the cost out of that specialty cost. Now it ranges from 13 to 25, but at the end of the day, if you just do that discipline, it matters. It really matters. And so you need to look at your network a lot differently. Payment realignment has to be there. We have to align it. How can it be that we can send a patient who gets newly diagnosed with diabetes, and we're going to have a lot of those, okay, and the average reimbursement mechanism today will cause the hospital system or the health system to lose about $280 by the time they do all of the counseling that they need to do for that new patient. Okay, we don't pay for that. But if we allow them to go on to gangrene, the profit on that amputation is $10,000. I mean, this is ludicrous. We can't have a payment like that. And so there's a lot of movement going on. There's no reason why we don't do payment reform. And healthcare reform actually gives us a couple of tools to do that. And then we have to do improved population health and wellness. We have to improve the quality and the reach of our patient condition management plans. We have a lot of wellness programs and a lot of disease management programs that are set up, and we have these parties, and the people aren't coming. Okay, the participation rates are unacceptable. That's where this new lever that you have has to be employed, and you have to get people engaged in that. You're going to have to make very steep cliffs for those who won't get engaged. We have no choice. And then we have to obviously have the improved employee engagement. So thank you.
Good morning, everyone. My name is Stacy Conrad. I'm a healthcare consultant, and if you will allow me a little discretion in my presentation, I want to focus on how accountable care organizations and the Affordable Care Act, how all of this translates to the provider groups within our community, and what the providers can do to really play a significant role in increasing quality and improving efficiency and helping to deliver a more collaborative approach for our end patients. I have done work specifically with Aurora Healthcare over the last couple of years in building their Aurora Accountable Care Network. So again, if you will allow me a little discretion, I will be referencing Aurora just because that's my personal experience and what I can speak most comfortably to. But really the rules and the laws and the philosophies that I'll be addressing apply to all of the provider systems in our community as we all strive to be accountable care organizations. In terms of our historical healthcare systems, if you will, they really have been fragmented. I tend to draw the picture in my mind where you have this beautiful tall skyscraper of a building sitting on your right-hand side, and that is the insurance carrier. And there are floors within that organization that are built with quality people that are so highly educated and innovative and really want to provide tools and resources to best manage their insureds and provide benefit programs that are viewed as a value add that help their members navigate the healthcare system. On the other side of that grassy knoll in the middle, you have this other tall, beautiful building that is the provider system. All of the physicians, the clinics, the hospitals, pharmacies, All of the caregivers, again, same, floors, they are bursting at the seams to offer innovation and knowledge, education, resources, and tools. And sitting in the middle, you have that patient. They're sitting on the grassy knoll in between those two organizations, and you have the patient who needs full access to all of the opportunities in both of those buildings. And yet really historically, the only crosswalk you have between those two buildings, between the carriers and between the provider systems, is based on a provider contract. And I don't mean to minimize the value of that provider contract with the insurance carriers, but its primary purpose, not sole, but primary purpose is to define a fee schedule, a discount structure, a payment methodology, if you will, so that any time provider X performs a procedure, we know that the carrier is going to pay them Y. All of those floors of opportunity and innovation and resources are only connecting at that one crosswalk. And so for me, what's been exciting is to see the accountable care organizations and the idea of that provide opportunity for us to create crosswalks at numerous levels so that we can really collaborate between provider system and insurance carrier to best serve that patient. Accountable care has to be multidimensional, and here the slide references 3 ways. It's really 4 ways. When you think of the image that I just described where we have provider systems and carriers and we have that lone patient sitting in the middle, the patient is really the most critical component. We have to have their engagement, we have to have their involvement and take their feedback to heart, because the true value proposition of a successful accountable care organization is the success that that patient experiences. What quality are they receiving? What improvements to efficiency? What does their overall patient satisfaction look like? And really, what are we delivering to them in terms of the outcome? Because all of us have been patients. We have family members that have been patients. The outcome that we achieve for our episode of care, for whatever disease state or illness state that we are trying to treat, that is what will define singularly what the success of that accountable care organization is and how successful were the parties in collaborating with each other. And then certainly, the common denominator between many individual patients and members is the employer plan. It's the commercial plan that we all access our health care benefits through, that we in turn go and see our physicians and seek care and services for. So having employer engagement is critical as well. Hopefully there are some employers in the room that still feel health care benefits are a perk for their employees. I can remember a time not so long ago where I think that that was more of a common theory and a common practice, that health care benefits and the health care that we received was a perk. It was a perk for retaining and attracting employee populations. Now it's something that is really at risk, and we need to focus back our attentions on making that a perk. Healthcare integration is key. I have the luxury of working alongside of Aurora Healthcare, who intentionally or unintentionally is a little further along, and maybe it's been a little bit of an easier jumping off point for them because they have been integrated, and that's something that they've strived to do over the last several years. A lot of provider systems in our community, though, are all taking steps through being an accountable care organization to deliver that same value of integration. And when you think about this in terms of practical terms, it's very important to us as patients. If I go to see a specialist tomorrow, I would like for that specialist to have an understanding of my healthcare history without my having to sit there and belabor the point for a half an hour or having to drag my medical records across town and bring them with me. Likewise, I would like my primary care physician to know what the results of that specialist meeting were, know what diagnostic tests I've been sent for, know what prescriptions have been prescribed for me, help follow and coordinate my care and be integrated with me. That's going to create a lot of improved efficiencies while still hopefully gaining quality and increasing quality measures as we move forward. Inefficient tests, duplicative tests, unnecessary testing, all of those types of things we can pull out of the system if we're integrated. So that's something that every provider system can work to achieve, and I believe through being an accountable care organization and the requirements in terms of data analytics and integration, it's something that will collectively raise the bar across the country and in our community. For Aurora specifically, and again, please allow me to be a little more focused, the goal for Aurora was to leverage their accountable care delivery system and their integrated care delivery system. So the fact that they already had these tools and resources to have medical home and records that are shared among all of their providers, they were able to really leverage these tools to deliver a product, if you will, straight to that commercial market, to the employers and to the employees that you all employ. They wanted to provide long-term measurable improvement. And again, Aurora is a little bit luckier than maybe some because they have been doing this for so long. They have the value of that data. They have the ability to dig through their archives of all of the paid claims that have come in across all of their patients, their 1.2 million commercial, Medicare, Medicaid, what have you, regardless of what insurance company they're coming in through. They have the ability to historically cull through all of that data and really quantify, have there been savings? And that's what they strive to deliver now in a very measurable and external-facing way. Also, the flip side of the coin is that this is not just an external message and an external product. We need to change the way that the provider systems operate, both within their four walls and then how they collaborate with insurance carriers, and it goes back to that contracting issue. We really need to turn the freighter around and make sure that we are incenting and rewarding our caregivers to deliver the best care possible, to deliver the best outcomes, the best quality, the best efficiency. As Jerry alluded to before, not all physicians are entirely equal. They have different practice patterns, different beliefs. They weren't all A-plus students, I'm sure, in medical school. And we have to be realistic and we have to be willing to do the hard work of looking at our providers and our practice protocols and our best standards, quality and efficiency, and see where do we need to make those improvements. And we need to reward and align our physicians and engage our physicians in that conversation. I think I've said this already frequently, but the core values that Aurora looks at, and I believe all provider systems should be looking at, is quality, efficiency, and patient satisfaction. These are core principles that every provider system in the state of Wisconsin, and I'm sure across the country, are looking at and benchmarking against, and they really become the philosophical pillars that you build an accountable care organization and network upon. I won't belabor this slide. It really goes to Aurora's evolution of care. But from a general focus point, the provider systems all have incredible quality and initiatives, efficiency initiatives. Every provider system in the state of Wisconsin, and we're very fortunate because we have some incredible provider systems here, they all have an inventory, if you will, of the things that they do best and the quality that they've been able to demonstrate, whether it's through CMS demonstration projects or just individual projects and initiatives that they've taken on within their four walls. They all have an inventory of things that they can quantify, that they know they can deliver on with great confidence. And so the trick is, how do we inventory those items? How do we really leverage them? Define what was achieved in terms of quality and efficiency. Put a return on investment to it, and then how do we take that out and collaborate with the insurance carriers and with our employer customers to make sure that we are delivering and validating on those promises. And again, this just goes over some of the different items that Aurora has looked at. I do want to look at a couple of the last two bullets, if you will. If we go back to the idea of contracting, and that original crosswalk that existed between carrier and provider, where we're looking at a fee schedule, a discounted arrangement. We really do need to change the dialogue, and Aurora looks at the episode of care, and this is where that integration comes in, and everyone, all provider systems will be starting to use this language, I think, going forward. You have to look at the entire episode from the day that you're diagnosed until the day that you're told you're free and clear and healthy again and you can resume your normal activities of life without threat or concern of that medical condition. You have to be able to evaluate the entire episode, and that's where you can data mine and really look at where are your areas of opportunity to make improvements. If you're just looking at a unit price and an individual unit of resource that's clinically provided to you, you're not going to get there. It's overwhelming. You have to have some sort of guardrails that you can put around it to truly do a detailed analysis. And then again, you have to have that reimbursement model changed. You have to have your caregivers involved and engaged from day one, and you have to have them helping you understand how to redirect the reimbursement methodology. If we're treating a diabetic, as Jerry mentioned, it's not about the unit price of the individual clinic visits, diagnostic tests. It's about what was the overall outcome, what was the return on investment for that episode of care, what were the quantifiable improvements that can be very clearly identified. For those of you that have been in this community, obviously you're familiar with Aurora's direct network. This goes back about 10, 15 years ago, and it really, I bring it up because it goes to the evolution and the innovation and the path that Aurora specifically has taken, but that we'll see many of our provider systems and carriers following suit with. Previously, the Aurora Direct Network was really nothing more than a directory of Aurora providers and a discount that was attached to it. If we move forward, this is what the Aurora Accountable Care Network looks like, and it's really our next step, our next evolution. It focuses on key deliverables, improving outcomes, again in a very defined manner, reducing trend, and being able to put a guarantee to that, putting a stake in the ground that Aurora has accountability for cost, for spend and trend, and for those quality and efficiency measures. Defining quality and efficiency, transparency, and again, transparency being across the episode of care, not just an individual, where am I going to get the cheapest MRI? What are we going to do for you as a patient across your entire episode? Patient-centered approach. If you think back to my visual, two beautiful skyscrapers and that patient sitting in the middle of those buildings, we have to always be modeling towards what the patient's needs are. And then a return on investment. And that return on investment impacts all of those accountable parties that we talked about, the provider systems, the caregivers, the insurance companies that are designing your products and your plans for you, the employer group, and certainly the patient. And it's taking all of the different values and assets that the provider system can bring to the table and really putting them within this bubble of accountable care. Aurora is able to very clearly identify what its results are, what its return on investment is. And I'm going to walk you through a couple of slides that indicate how Aurora was able to do that. But this gives an idea of all of the different research that was done over an almost 3-year period in determining if Aurora was well suited to take this approach. And I can only assume that other provider systems in town are taking the same similar steps. One of the greatest things that Aurora has going for it is it's the largest employer in the state of Wisconsin. So obviously they have an employee population that they are caring for. We've done a lot of research looking at episodes of care, not just analyzing unit price costs. And we've done a lot of analyses with our payer partners, all of the major insurers in town. In terms of Aurora it being that large employer and struggling with a lot of the same things that other employer populations are struggling with, I would just like to point out that as a caregiver and as a group of caregivers, insurance companies generally tend to price them higher in terms of their health care. A, because they know exactly what care to seek when they're ill or they have a family member that's ill, and B, they have ready access. They're there all day long. So they tend to utilize more healthcare services, and they tend to be more riskier in terms of their general underwriting. And yet Aurora runs 7% less in terms of claim costs than what we see among our commercial patient population that comes in and out of our door. And again, that's agnostic of carrier partner, just in terms of sheer employer commercial claims. This is one of the analyses that Aurora undertook in order to determine whether or not they truly were more efficient. When I joined forces with Aurora, which was several years ago, working for them in a consulting capacity, it was widely touted that because Aurora was integrated, they were more cost effective and they offered greater quality and efficiency than they felt that their competitors did. Yet no one was ever able to qualify that and to quantify that. I would go out and I would meet with brokers and consultants in the community, some of which are in the room, and other than taking my word for it and my taking Aurora's word for it, there was really nothing to validate that. So what's been exciting for us is that Aurora has now started to do the analysis to truly put that out and be able to quantify it for the marketplace. This gives you an example, and there's some great things on here, and there's some not so great and attractive things on here, but it gives you the full picture. What Aurora tried to do is take its major clinical categories and break it into their 3 regions. So south obviously being towards Racine, mid-market being Milwaukee in the greater area, and north being up towards Green Bay. And we look at how is Aurora performing, again, on the episode of care versus how is everyone else performing versus how is the community, Aurora and everyone all together pooled. And that gives us a foundation for discussing with our clinical teams and our caregivers where is the opportunity for us to be improving quality and efficiency. It also helps us be more transparent to our carrier partners and to our employers and our patient customers as well. This is an example where we took the value of integration and again, looking at the entire episode of care in a claim population. So not getting into the specifics, just here's claims data, raw claims data, sorry. Let's look at what the episode of care looked like under Aurora treatment, and let's model what that same care would have looked like if we pulled it from an outside provider system into Aurora. And that's where we define our value of integration. It's certainly much more complex than I've made it sound to be, but that is at the heart of what we're trying to accomplish. And for this particular book of business, which was a sampling of fully insured small and large group united cases, we were able to demonstrate a 14.6% value of integration utilizing Aurora facilities on those episodes of care. This gives you an example of other analyses that we've been able to do, and this really ranges anywhere from an individual large group employer where we had their claims experience and some of the carrier partners, as I mentioned before. The carriers have been wonderful in working with Aurora to provide us with their books of business, their commercial books of business, so that we have all of the fully insured claims for a carrier from the past 3 years, and we can go in and we can run those claims through that same analysis I just referenced. And we can identify, is there an opportunity for Aurora to really have an impact? And if so, what is that level of impact? Hopefully that allows us to translate into those contracting discussions with our carrier partners so that they're pricing premiums accordingly. Aurora can share risk and really have an accountable stake in what that healthcare plan looks like, and we can deliver guarantees to that employer population and that carrier forward. The Aurora Accountable Care Network focuses, as we've talked about, every physician has to have a stake in the game. Every patient is at the center of all of our initiatives, improving their health and wellness. And we need to have very strong partnerships with our employer customers because they really are the gateway for us being able to interact more effectively with that population. The employer value that's to be achieved through ACOs, and I think this is really the staple of what we're discussing, it's holding the provider system accountable, and they want that. They're ready for that. They're ready to validate for you what they do, what they deliver in terms of quality and improvements and efficiency. So leveraging the value of your healthcare spend, empowering the employer community to do that, making your dollars feel more like an investment, not an expense, holding providers accountable for results in a very measurable way and long-term manner, integrating your healthcare costs across the employee's life, across their continuum of healthcare, and letting the ACO, that accountable care organization, both provider system and carrier, respond to your specific employer population's needs, giving us feedback, really engaging with the provider system, not just the patient to doctor level, but really engaging those organizations and leveraging them to the benefit of your employees. And hopefully this is what we achieve. at the end of becoming an accountable care organization. And obviously this is going to be a much longer path for all of the provider systems in the community, and there's going to be some bumps in the road and some strategies that we'll have to really tweak and make sure that we're moving forward with accordingly. But it's looking at consolidating the carrier relationship, the provider relationship, the employer, the employee, providing all of those tools and resources in a very collaborative manner, improving the quality, efficiency, and financial predictability for our patient population and our employer customers. So, thank you very much.
Time frame. So if everyone could take their seats, and we will have a chance for Q&A after we get through the next two speakers. I introduced this gentleman before, but we have with us Kevin Moore, who is the Executive Assistant #3 guy in the Department of Health Services. So please join me in giving him a very warm welcome.
So everybody just keep eating, please. And I want to apologize. My 4-year-old daughter gave me this gift, so I'm the one hacking in the corner, so I apologize. Again, my name is Kevin Moore. I'm the Executive Assistant. I have one of the worst titles in state government. There's secretary, well, except for maybe you, Dan. There's secretaries, deputy secretaries, and executive assistants are the third person at the department. For those of you, and Tracy mentioned this before, the Department of Health Services is outside of K-12 education, and arguably actually bigger than K-12 now that I think about it. We have a biennial budget just shy of $19 billion every 2 years. We have 7 facilities, 2 mental health hospitals. We have 1 facility that's designed for people that are sexually violent individuals. We run a facility for psychiatric treatment for prisoners, and then we run 3 centers for people with developmental disabilities. In addition to that, we run Medicaid. In addition to that, we run public health. In addition to that, we actually regulate nursing homes and hospitals. So, and then we actually try to do a couple preventive things along the way as well. So to say that we are a large agency is an underestimate. As I was joking on the way here, this part of the presentation here, there are no slides for this presentation. That was my fault, actually, originally, because a week ago, I didn't have slides, primarily because I wasn't quite sure what to put in the slides. And now, after what's happened in the last 7 days, I'm actually glad I don't have slides, because everything that would be on the presentation would have to get thrown out, because in the last 7 days, there have been some very large decisions that have been made that are going to set the course for the state of Wisconsin over the next couple months, weeks, years, and possibly even generations, depending on how this thing plays out. One of the first things I want to do is kind of go through some timelines so that everybody kind of is on the same page. And I think this will set a good stage for both my presentation as well as for Dan's, because Dan and I are going to kind of work back and forth. I'm not an insurance guy. Dan is. So if you got questions on insurance, just hang on a second, because I'll just defer to Dan anyway. When Governor Walker took office back in 2011, January 2011, there was an office of what was called healthcare reform. It was a joint effort between the Office of the Insurance Commissioner and the Department of Health Services, and it was designed to actually develop a statewide exchange and to help Wisconsin move forward in implementing healthcare reform. Now, one thing I'll just throw out there to make sure people understand, PPACA, or the Patient Protection and Affordable Care Act, is a really big boat, okay? And for those that know how bills, how I'm just a bill on Capitol Hill, it's got everything in it, okay? There's stuff in there on long-term care. There's stuff on there on wellness. And then there's a section of it which is healthcare reform or Obamacare or whatever you want to call it. So when this came up, Governor Walker kind of continued the tradition of this office staying open. He renamed it as the Office of Free Market Healthcare. And the goal was to develop and create a statewide exchange based on free market principles. We moved forward through 2011, and we continued to work with the federal government. We received an early planning grant of about $32 or $38 million. 38. Received the money, we continued to build. Earlier this year, in January, however, we kind of got into a fork in the road. The governor had a decision in front of him, which was, do we want to continue to build a statewide exchange, or do we want to kind of hold off? As Tracy had mentioned before, we had a national lawsuit that was pending, and then we also knew that 2012 was an election year. So the governor made no qualms about his opposition to the Affordable Health Care Act. He signed on as along with the Attorney General as a plaintiff, I guess it would be. Again, I didn't go to law school either. And so Wisconsin had kind of positioned itself as being against this particular piece of public policy. So in January, the governor gave made the executive decision. Office of Free Market Health Care was shut down. All development on a statewide exchange was stopped, and essentially the money that was still left outstanding was, cordially returned back to centers of Medicaid and Medicare services. Fast forward, June 6, 2012, it comes, we had an election. That election moves on. Supreme Court case comes down. And I'll just give you an example of what happened in the Secretary's office as we were watching diligently on the television. We, like everybody else, read the first, do read on. We read the first thing and we thought, okay, this is done, game over, we're finished. Read page 2, okay, what does that mean? Read page 3, oh, great. By that point, everybody's dance had kind of gone into, okay, what does this mean? And it wasn't until we moved on to the Medicaid expansion provision, where for those of you who know Secretary Smith came from CMS. He was the Medicaid director under President Bush for 6 years. It wasn't until we got to the Medicaid provisions that all of a sudden I saw, and I don't know if I'd call it a twinkle in his eye, but there was this unique response from Secretary Smith where he looked at me and he said, I don't know if this is as bad as it potentially could be. And what he was referring to was the Medicaid expansion argument, or the coercion argument that was eventually struck down by the Supreme Court. Essentially, the PPACA law said you have to expand Medicaid to 138% of federal poverty level, or else you lose your base Medicaid payments. Now, for the state of Wisconsin, in terms of our match, for every 40 cents that we put into state dollars, 40 cents of state dollars draws down approximately, well, it's a little different now, but 60 cents of federal dollars. So when you're looking at a $7 billion program, that threat carries a very, very big hammer. But now all of a sudden it changed. Now we didn't have this threat of losing our base Medicaid funding if we chose not to expand Medicaid. It was a game changer. It empowered governors at that point to make decisions based on what was important for their individual state. So we kind of went along a little bit. We wanted to kind of see what was going on. At that point, Tracy had contacted me a couple times. We were trying to figure out what does this mean? What does the future hold? So as we continue to move on, we had, again, presidential election. We wanted to see, obviously, a very different view about what the future of healthcare exchanges would be in the view of Medicaid. So election came. President Obama wins re-election. 10 days later, we had to tell the federal government whether we were going to do an exchange or not at the state level. And actually, Jerry's presentation made probably, I should probably steal one of your slides, Jerry, made one of the best arguments as to why the governor made the decision like he did to go to the federal exchange. Because a lot of this stuff is pre-cooked. Federal government's saying you have to do this, 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 and this. So the question is really who's administering the exchange and who's going to go back to the insurers and require them, or taxpayers as it were, and say you have to pay for it. In those meetings, it was very clear that the governor had a very distinct opinion on this, and then on the 16th of November, OCI, in conjunction with DHS, communicated back to CMS saying we're going to default and go to the federal exchange. So that was 4 weeks ago. So then the next question shifted to, we're getting ready to the budget. Governor's been working with DHS and agencies. We're trying to figure out what to do next. When the Department of Health Services submitted our state budget request, it was dry white toast. It was how much is it going to cost to keep the lights on right now. That number in and of itself was $650 million in state money, okay? And again, if you go through the math, and I don't have my computer with me, but add another 60% onto that, and that's the overall spend and growth in Medicaid with no Medicaid expansion and just continuing to pay what we're currently paying. Kind of a subnote of that, which was important, is that out of that $650 million, $200 million of that was because the state of Wisconsin is actually, the way they calculate our federal match rate, Wisconsin is actually going down in terms of the amount of federal dollars that we're able to claim. So it's about 1% to 2% change in the matching rate is going to impact Wisconsin taxpayers by between $200 million and $250 million in the next 2 years. Now, again, that's just to keep the lights on. That's not expanding anything. That's building in a lot of our healthcare efficiencies that we've been doing over the last 2 years. That's not, you know, a lot of this cool stuff we've talked about, medical homes and all this other, these are things that would be above and beyond what we're talking about right now. So in Wisconsin, we had a kind of a unique situation. Wisconsin has been traditionally a Medicaid state where we offer above and beyond benefits to people. Our eligibility requirements are much higher than they are in other states. Some states have eligibility as low as 17% of the federal poverty level. Here in Wisconsin, though, you have eligibility rates for example, for childless adults. There's a small group of people that are childless adults that can go up to 200% of the federal poverty level. For pregnant women, we go to 300% of the federal poverty level. So we're way above that 138 in a number of these populations. But one population that we don't have the expansion to is childless adults. Wisconsin, in 2007, the state budget authorized the Department of Health Service to move forward with providing care, and it was done in a budget-neutral type of setting. That you may have heard, remember, enrollment went through the roof so fast within a couple of weeks that they actually had to stop enrollment and they put a cap on the program. That cap has remained in place, and so right now what used to be about 65,000 individuals has now gone down to under 30,000 individuals. But as you might guess, those people that are still in the program are pretty sick because they're recognizing that the value that they're getting moving forward. So that was all designed to tell you that we had some decisions. The governor asked us, has asked the department, and we continue to try to figure out, you know, what models can we do? What information do we have from the federal government? Again, there's no slides for this presentation because we don't know what the federal government's going to tell us. Because one day they say one thing, and one of the things that was said in here is you hear a lot of proposed rules or draft rules or concepts or phone calls. That's not how you build a business, and it's not how you run an $8 billion a year insurance company. Well, maybe it is, because I'm state government. Maybe people think differently. But it's not the way we want to run our business plan. So in the concept of better to be lucky than to be good, 2 days ago, the federal government comes out and says, hey, guess what? You got two choices on Medicaid expansion. You either do it or you don't do it. There's no in between. And the reason why this whole thing is important for the state of Wisconsin is because the Medicaid expansion is being funded at 100% for the first couple of years, and then it's going to go down to 95% and 90%. So you, from a political perspective, I can insure a ton of people, and the federal government's going to pay for it for 2 years. Well, what happens after year 3 or year 4? And these are the questions that we have to figure out. That at one point we were trying to determine if could we do a part-time expansion? Was that something that is eligible? Could we expand for childless adults? Again, one of the things you saw in the exchange argument is it's 100% to 400% for purchasing health insurance in the exchange. So it's like how do those things connect? If you've got 100% eligibility for people, it's a pretty easy connection. But now that they've made this change, it's kind of a game changer. Again, it's another game changer for the state of Wisconsin. We now are in a position of going back to the governor saying, you have really one choice. You can go to 138% of federal poverty level, or we can continue the program as it is. Now, that's a policy decision. That's a benefit side decision. But there's another part of this entire thing that's not been talked about today, which is how do you make the thing work? How do you turn this thing on? What's an exchange look like? Because arguably Massachusetts is the state that is light years ahead of every other state, and the last I read they're at 58% to compliance based on the federal rules. So the state that's been doing it for such a long time, they're not even 2/3 of the way there. So what we're trying to do right now is determine what's the impact. And again, this is what I know. I'll let you guys kind of make your own decision. We know that right now we can't do partial Medicaid expansion. We've either got to expand it or not expand it. And again, the population primarily in Wisconsin that's going to be impacted is going to be childless adults. 2, we know regardless of expansion, we're going to have people coming out of the woodwork. We're going to have people all of a sudden, because of the exchange, that may not be eligible for exchange because they're at 50% of the federal poverty level and they're not on Medicaid now. Guess what? They're going to be in Medicaid now. So we know we're going to, without even making a change in eligibility, we're going to have more people coming out. Second thing is, you got to run administratively each person through eligibility. So now you're going to have people coming out of the woodwork again who maybe they're at 200% or maybe they're at 400% of the federal poverty level. They're going to walk into Miles over on 12th and Elite, and they're going to sit down and say, am I eligible for Medicaid? I've got to then pay for somebody to actually run eligibility for that person, only to say, no, you're not. Here's the exchange. Now, for me, it's a budget issue. For you, y'all paying for it because this is the one part of the whole thing that is 100% taxpayer funded, whether it be the administrative side of it or the benefit side of it. So what's happened is that Secretary Smith actually tomorrow is going to be testifying in Washington before the House Committee on Commerce and Energy. I always want to say Energy and Commerce. But he's going to talk about the implementation of Obamacare, of PPACA. And really what we're going to talk about is how do you turn this thing on? How do you make it work? Our biggest challenge right now is that this is all built off of exchange of data. This is all our ability to determine that Kevin is eligible for fill in the blank. Now, within Medicaid, I can do that right now. If somebody's coming in and wants to know, am I eligible for Wisconsin Medicaid, you plug in my information, you plug in my income, boom, 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 yes, no, okay, here you go, enroll in a plan, don't enroll in a plan. It's pretty self-contained. It's also a 30-year-old IT system, but let's ignore that little hurdle right now. But now that you've got this other eligibility, now you've got eligibility for the federal exchange, which, by the way, I don't know if you guys know it, but I don't know what that looks like. I don't know how it bolts on. I don't know what's the front engine. Again, another IT issue, but there's a lot of business questions that need to be answered. We've got to try to figure out how to exchange information back up between the IRS, Department of Revenue, Department of Workforce Development, Department of Labor, all of this real-time stuff that everybody's talking about. That doesn't happen with a snap of a finger. Because again, I got to plug in my 30-year-old eligibility system, which doesn't even talk to itself some days, and it's built on a mainframe. I got to plug that in now to whatever the federal government comes up. And I'm going to tell you a story that it'll be in Secretary Smith's testimony, and it's designed to be a nightmare for you. Because again, the line is, you're going to trust healthcare to the entity that brings you the IRS and things like that. We want to be able to do a real-time data match on Social Security numbers within Medicaid. Pretty straightforward. SSA and the state of Wisconsin, let's talk. That's all we're trying to do. This project started 13 months ago. We now can batch information. So we get to give them a bucket of information. They take it, they run through it, and they give it back to us. It's only taken 13 months. That's just Social Security numbers, and I'm not running in real time yet, okay? So now let's stop and think about it. Now I got Social Security numbers, I got W-2 numbers, I've got unemployment, I have child support, I have all of these other things out there that in the private sector would be a nightmare in and of itself to do, and now I got to figure out how to plug this in. Not me. We'll probably pay somebody to do it. The federal government will probably support us in doing that. But that's the real-time problem that we're facing. And I'm not even getting into the issues of how do you pay the tax subsidy? How do you have a prospective tax subsidy, and then all of a sudden somebody comes in at the 11th hour and says, I made more money than I thought I was going to make. Now all of a sudden, guess what? Here's your tax bill. Have a nice day. So those are the issues that we're facing. The part that scares me the most, though, besides all that other stuff, is that while we're working towards expanding Medicaid, there's a lot of this other talk in Washington when you talk about deficit reduction and when you talk about how is the federal government going to get their house in order. And there's a phrase that's used a lot that scares me a lot, and it's called blended rate, okay? And blended rate means right now, as I've talked to you about different things, benefits is a 60-40 match. IT might be a 90-10 match. Medical homes are 90-10 match. If they start to blend that, blending in that case only means I'm going to go from 90-10, I'm going to start going to 60-40, or I'm going to go to 50-50. What happens is all this IT stuff and all these benefits that we're talking about that are enhanced, that cost is going to get shifted over to the state. And given the last two budget cycles, where the first budget DHS asked for $1.2 billion And again, that's just to keep the lights on, and we got it. $650 million this budget cycle, and I'm hedging my bet we'll probably get pretty close to that. That's based off of these enhanced matches. This is based off of 90-10. This is based off of 80-20. So if they're serious about saving money, they're not going to save it on the benefit side. They're going to save it on the IT side. They're going to save it on the admin side. And the problem is that that side is going to be critical to make an exchange work with the state Medicaid program, and ultimately as businesses and providers, that integrity of that system is going to be incredibly important to y'all. And again, there's no slides for this presentation because I don't know what that's going to look like. I don't have an answer for you. Now we're working through it. Hopefully the Secretary's testimony tomorrow is powerful. Hopefully somebody listens. You know, there's always the concept of delay. There was, Jerry, I think what you said, just push it all onto the states. You know, I think there's a lot of things out there, but at the end of the day, we still have a program that we have to run that's accountable to you, and then we have to try to figure out all this other stuff. Dan will talk a lot about how the state's trying to interpret the rules and what are the rules. These are all the challenges that we face. But at the end of the day, as we move forward, we have to make sure that that the integrity of our program, we're ultimately responsible to you as taxpayers. So we'll make it. We'll figure this out. It's going to be challenging. But I think that at the end of the day, these are the things that keep me up at night. But know that I don't want you to go, you know, don't lose too much sleep. IT problems are my problem, not your problem. But these are the things that are important. And if there's one punchline is, this is what happens when you have this big of a program. This is what happens when you bite off more than you can chew. The timelines, all this stuff. We can't do project plans because we don't know what we're doing. And none of you would build your business or build your provider networks or build your consulting firms. You would never do this. And yet we have a deadline. We've got a clock that's ticking. And so I'd just say stay tuned and continue to ask questions and continue to be skeptical, but continue to ask for results from people. So thank you very much.
I have a question for you, Kevin. Do we know how many newly eligibles there would be if we expanded Medicaid to do what was required by the ACA?
To get to 138?
To get to 138.
It really depends on the number of people that you expect to come out of the woodwork. So that number could be anything from, I've seen numbers going on the low side anywhere between 75,000 to 80,000, all the way up to potentially 130 to 135,000. Just to put it in perspective, there's 1.1 million people on Medicaid right now. And on the health insurance side of it, remember Medicaid's got two parts of it. There's the acute and primary, so it's the insurance side, and then there's the long-term care side of things. There's about 750,000 individuals and children that are in there. So if you take a look at 750 plus, let's just take the high water mark of, let's just say 150,000, that's a pretty large expansion in the number of people.
Do you know what the cost estimates are to cover those newly eligibles?
No. And the reason why I say that is because it depends on how you define a newly eligible. Wisconsin already covers childless adults. And so since we already cover it, if I expand the program, am I expanding something that's already covered, or is this a new population? And the difference is the difference between 100% federal match or 60-40.
It's clear they're new.
They are new?
I'm saying it's clear because we're going to get 100%, right?
Well, and yes, the 30-second ad that's been paid for by Jerry, that's the problem, is that there's proposed rules out there. And Wisconsin is unique because we are kind of stuck in the middle on this. But the shift in dollar amount for expansion is huge. So we have to literally run two different sets of scenarios. And those scenarios are built off of what's your uptake on the woodwork effect. Again, do you go 100, 138? Where do you plug this in? So we've been kind of sitting back, not really, you know, we'll look at the numbers and try to figure it out. But ultimately, like I said, earlier this week, the decision to say you have to either go all or none, that basically throws all my other spreadsheets and throws them out the door.
And just a reminder, those that are not, maybe Medicaid eligible, but the state hasn't expanded, those individuals will still have this shared responsibility payment and will end up on the exchange unless they have financial hardship. So,
and that's I think a question is that if, and again, I don't know if this is a political lever, but the matching, or the subsidy that's coming in the health insurance exchange is 100% to 400%. So the question is, in Wisconsin, there's a cohort of people that are 100% childless adults and below. I don't know where they go. Because if we don't expand, and this is, I think, kind of the political brinksmanship that's going on, and that they're banking on the pressure being so high that they're gonna expand it and we'll move it. But if that population, so if a childless adult that's at 75% of the federal poverty level, they're not eligible for Medicaid because we don't expand, they can't get the subsidies in the health insurance exchange. Again, talk about a faulty drafting of the bill. And again, I'm not even talking about whether or not the subsidy in the federal exchange, that's different. This is just mechanically, and I think one of the things that I've used is that's important is, I think if you think of Medicaid eligibility as a foundation of a house, and you think of the exchange as something that you build on, if you have a number of different layers in your foundation or in your basement, it makes the cost of the house that much more expensive to build. The federal government was banking on 138 for every single state in the union. That's why they put the screws to it. That's why they said, look, you've got to do this, otherwise I'm going to take your money away. When that went away now, Wisconsin is at 200 and 300. Indiana is at 17. And, there's some states that are incredibly lower. So how do you build an exchange that bolts onto Wisconsin? And the other state, Tennessee, yesterday just announced that they're going to go with the federal exchange. Their eligibility is substantially lower than ours. So now I've got to build two houses, and keep in mind, I don't know how to build a house. I have to build two houses that go on two different foundations that are substantially different. So that's really the punchline that I can that you should take away is that these are all the intricacies that, regardless of all of these guys did a great job. I'm looking at just how do you turn the thing on? And I hope that you get the distinct impression that we're not quite sure.
Our next speaker is Dan Schwartzer, who just joined us, and he is the Deputy Insurance Commissioner in the state of Wisconsin. He's also been appointed as the chairman of the NAIC's Healthcare Regulatory Reform Alternatives Working Group, which is comprised of, I think, governmental officials that are really trying to figure out how to deal with the exchange, the benefit exchange, and also the other issues that relate to the PACA. So without further ado, we're glad to have you here, Dan Schwartzer.
Good afternoon. Thanks for having me here and to talk again about health insurance or healthcare reform. I was giving a speech a couple days ago to some Rotarians about healthcare reform, and I noticed that some folks were sleeping, and they included myself because it was that exciting. So I immediately stopped my speech and said, we're just going to go to questions and answers because it's going to be easier. So I would just encourage you as we go through this presentation, and I also have no slides. I'll explain that in a second. I just encourage you to ask questions as we're talking about that particular subject matter, because then it focuses on what you want to hear and the questions that you have versus me rambling on about something that we have no slides, partly because of what Kevin said, which is it's always changing. You don't know what you have, but we also don't really want to put anything in writing that we'd be held accountable to. So that's really the main reason I don't come up with slides. Just a real quick synopsis of our agency. We are a little smaller than Kevin's agency. We have 140 employees versus 6,000. But those 140 employees really regulate the entire insurance market in whole. We have 380 domiciled carriers in the state of Wisconsin that we're responsible for. There's over 2,000 licensed carriers that we regulate. Over 118,000 licensed agents, and so for a very small staff, we're like the 5th in the nation in terms of numbers of domiciled carriers and in terms of an insurance market. So a lot to do, and then we add on that healthcare reform, and it makes for a fun agency. I'm going to talk very briefly, because Kevin kind of got into why we made the decisions we made and I'll focus more on what we're doing going forward post-decision. But I do want to spend just a couple of minutes on where we were at and why we made the decisions we made, because we can say that we stopped all production on the exchange and just said we're against it. We want to see what the federal government comes up with in terms of the Supreme Court. We want to see what happens in the election, and then we just don't want to do the exchange. There was a lot of pieces. Kevin really brushed over those, and I'm sure purposefully. But there's a lot of pieces that went into that, and I think it helps you understand, at least from the insurance regulators' perspective, as to why we made the decisions that we made. The first is the tremendous amount of research that we did, the R&D that we did for almost an entire year on trying to analyze what PPACA would mean to the state of Wisconsin if it was implemented in its entirety. And a lot of what we looked at was off of a study done by Gorman Actuarial and Dr. Jonathan Gruber. And you've probably heard us mention this many times, but we put a lot of weight on that particular study because we knew that would be the floor, meaning it's going to be a lot worse, we think, than what Gorman and Gruber are saying. But we felt it was at least we would know what the floor was. And one example of what I mean by it'll be worse than what they're saying is in their calculations they had that there would be an automatic 7.5% reduction in premium across the board amongst all insurers because they're competing against each other like they don't compete against each other today. And so, that's just one example. There's many more as to some of their assumptions that you just looked at and went, what? And so we believe this is going to be the floor, but the floor that they painted for us was extremely bleak, and quite frankly, it had Ted and I panicked. We have the most competitive insurance market in the country. We have 33 small group carriers that compete with each other on the group side, 25 carriers that compete with each other on the individual side, and you need to get past 10 carriers in both markets before you get to that 75–80% market share. And we promised ourselves when we walked in the door in January of 2011 we weren't going to be the guys that screwed that up. And then along comes Obamacare, and along comes the Gorman and Gruber study, and it's frightening. I mean, you've got huge increases in the individual market, you've got huge increases in the small group market, and they never even gave us what the increases would be on the medium and large group market. The excise tax alone represents a 2 to 3% increase in premium, and then you add reinsurance and risk adjustment, and you're talking probably another 2 or 3%, and that's just the excise tax and none of the other components. And so huge concerns from insurer solvency and the numbers of carriers that would be able to maintain and compete in the state. Had concerns about consumer protections, quite frankly, when you look at the navigators that are going to be out there giving advice about insurance. With just the navigator program alone, no ability to really go after a navigator, no financial responsibility of a navigator. Our regulatory scheme in Wisconsin, we think, works. When an agent gives bad advice, they have to have errors and omission insurance, and we go after them. And when that's not enough, we can reach through that agent up to the carrier and get whatever we need to make that consumer whole. And quite frankly, that's just not the case with the navigator program. So when you look at all these things, when we spent this entire year trying to figure out what this law actually means to the state of Wisconsin, we don't like what the effect of the law is, and so therefore to embrace going forward on a state-based exchange was a huge leap of faith. But we did spend, and Kevin was in those meetings with the governor and myself and Ted and Dennis, a good week back and forth on should we, now that we know what the presidential election results are, do we move forward with an exchange? And there were some very sound rationale and reasons why we didn't go forward with the exchange. One is the long-term risk to Wisconsin taxpayers. Kevin gave some great examples of those risks. Unfunded taxpayer obligations, and even if there is federal funding, it's not if it runs out, it's when it runs out. Wisconsin's left with that cost and absolutely zero ability to control the program for which we're paying for. Another reason we decided to not do the exchange was the federal government makes all the decisions. Eligibility, minimum standard of coverage, essential health benefits. Another reason we decided not to do the exchange was because even though they said they're going to make those decisions, they'll be flexible. HHS and society will be flexible with us. They'll give us the ability to regulate our market, the ability to develop an exchange that meets our needs in Wisconsin. Well, we have had 2 years to determine that those are false and empty promises. And I'm just going to give you a few examples because I think it sets the tone as to some of the things that we've been facing and going through in trying to make this decision. So it was not made in a vacuum. Rate review. They talked about how every state can be their own rate review to see if rates are excessive. So Wisconsin applied to be an effective rate reviewer for the feds, and they said yes. After a year, right now the threshold is an arbitrary 10% threshold. If the rate increase is 10% or higher, then you don't have to. Then you have to go through actuarial studies. You have to look at the state has to look at it because we're the effective rate reviewer and determine whether or not, after looking at the actuarial analysis, it was excessive. But after that first year, then you could apply as a state for a state-specific threshold. Well, our threshold is based off of what's the cost of healthcare cost increases in the state of Wisconsin. And so we look at a bunch of factors, including, do consumers have the ability to move and shop with their feet if they don't like the rate increases they get? They accepted that, but they denied our request for the second year when we said we want to do a formula approach instead of an arbitrary 10% threshold. And they said, no, we're not going to give you that ability. So there's one example. Another example is when you talk about rate review and the arbitrary threshold of 10%, we had grave concerns about what was happening, what we were already seeing in the marketplace. So the arbitrary number is 10%. We saw carriers submitting rate increases and their actuarial justification for increases that deserved 12 or 13 or 14%, and they were coming in at 9.9, 9.8, 9.7. Now, at first you think, oh, it's great, the law's working, it's reducing health insurance premiums for the state of Wisconsin. The reality is that nothing in PPACA, and this is probably our biggest gripe, nothing in PPACA emulates what our number one job is, our second job is in the state of Wisconsin as a regulatory agency, and that's insurer solvency. And so when you talk about the two things that every insurance regulator is supposed to do in the country, it's consumer protection and insurer solvency, making sure insurers can honor their commitments. And not only does the law not look at insurer solvency, it actually has incentives to hurt insurer solvency, and rate review is one example. Because if an insurer needed a 12% increase and they came in at 9.9, what's going to happen in year 2 or year 3? So we had some grave concerns about that. Another example is the whole idea of essential health benefits. You'll absolutely be able to do your own essential health benefits, figure out what's best for your state. You have a whole bunch of options, and one of those options is to look at the top 3 writers in the state and maybe blend some of those those benefits together and come up with it. Well, just the rules came out not too long ago, and we can't do that. You can't Frankenstein it. You have to pick either the third, the second, or the first, but this idea that you were going to be flexible and allow us to create our own didn't occur. So I mean, I can give you a lot more examples, but those are just a few examples of where we've had real history knowing that the promise of flexibility and the promise to devise something in our state that meets our needs just doesn't exist when you're dealing with HHS and societal. And then the last reason is PPACA really didn't allow for a Wisconsin option in our unique place in the marketplace. It was designed to try to create competition for a state that has one insurance carrier that owns 75% of the market, not for a state like ours that you need to get past 10 carriers before market share. So there was some serious rationale as to why we didn't do the exchange, and it wasn't because we weren't ready to submit a blueprint. The blueprint was easy. We spent a year before getting it ready. It was strictly based on all of the facts that we just mentioned and what Kevin mentioned as well. So now that the decision's made, what are we doing? How are we proceeding moving forward? Well, it's almost like there's 2 parallel tracks going forward. One is the Medicaid side, and regardless from an insurance perspective what we do, that track is going to take care of itself, and Kevin and Dennis are going to figure out what's best for Wisconsin when it comes to and when it comes to the insurance side, we're going to try to do what's best for our marketplace and to preserve our marketplace. A lot of our efforts, quite frankly, are going to focus on the work that we're doing at the NAIC. Just for brief background, the NAIC is the National Association of Insurance Commissioners. It is really it's a trade, but it's much more than a trade. It's where we go for resources to help us regulate our market the way that we want to regulate our market. It's also where you see many of the model regulations and the model legislation pertaining to insurance crafted. It's crafted by all 50 and then the territories' insurance commissioners getting together and coming up with what makes sense from a regulatory scheme and from a regulatory perspective. In that entity, NAIC, there are many committees, as you can imagine, because there's obviously tons of variety of insurance. And one of them is the B Committee, which we are a member of the B Committee. And for the last 2 years, the B Committee has gotten together to talk about how states can best implement PPACA as it's written and as going forward with state-based exchanges. Well, unlike many other states, Wisconsin was saying, well, what about a state that's not going to do a state-based exchange and they're just going to do a federal exchange and really try to retain control of its own outside marketplace outside the exchange? And so commissioners got together and said, yes, we need another group. And it's called the Healthcare Reform Regulatory Alternatives Working Group. And I'm not the chair of that particular working group, where Wisconsin is the vice chair of that. And then there's a legal authority group that looks at the legal authority, what states are preempted, or where state law is preempted, where it's not, and where there's a huge question mark. And I'm the chair of that particular working group. And the work that we'll do there is exactly that: determine where it's very clear in the law what we can regulate, what we can't regulate, what's preempted, and then where there are challenges or where there are questions is to challenge HHS and SOCIO and determine who's going to ultimately control that particular piece that we're unsure of. Hopefully those are just discussions and not court challenges, but each state has their own ability to regulate and to protect their market in any way they see fit. And so there potentially could be court challenges from states regarding those areas that are of question at this point. We'll look at things like when an insurer is participating in a federal facilitated exchange, do they have to meet every criteria that we have in the state of Wisconsin and able to, in order to market within the federal facilitated exchange? Things like if there is a navigator program, what of our laws survive in terms of trying to regulate misbehavior from a navigator? Is it just the federal law, or can we have personal financial responsibility laws on people that give advice on insurance? It'll look at items such as when there's a consumer complaint regarding an insurer, who handles that consumer complaint? Do the feds handle that consumer complaint, or does it come to the Office of Commissioner of Insurance? So those are the things that we're working on right now at NAIC at those working groups. We'll probably spend, I would guess, the next month and a half trying to put all of those areas into the buckets I just talked about. And then the buckets that become those question mark buckets is begin discussions with HHS and SOCIO about what we do with those that are undefined at this point. We will also work with the industry. We've already begun some discussions with some carriers and agents on what do we need to do in our state to preserve our market. A good example is when you get into open enrollment within the federal exchange, it's very clear there's an open enrollment period in the federal exchange, which means you can only apply for insurance within a certain period of time. And once you've applied within that period of time, they have to accept you. Every carrier has to accept you. Well, if we don't change our law in Wisconsin to make it an open enrollment period in Wisconsin, that means people could only go into the exchange in October, but someone that decided they weren't going to get insurance and then get sick in February could sign up for insurance from one of our carriers outside of the federal exchange. And if we don't change our open enrollment language, our carriers in the outside market would be adversely affected. So it's those types of legislation, it's that type of legislation, it's that type of regulation that we will spend exclusively focusing on to determine how we preserve our marketplace so that we retain the same amount of carriers competing with each other, because in our opinion, the best consumer protection we can give is choice and competition. And we want to continue preserving that choice for our consumers. So that's a very quick overview of what we're doing on a go-forward basis, but I would be happy to answer any specific questions that you have either about NAIC, the working groups, or anything that we've done in the past so far. Thanks.
Just a quick note, 2 days ago the Obama administration gave conditional approval to 6 states who will operate their own exchanges. There are a number of Republican governors who've said they won't, and Chris Christie, I think, was the most recent to take that approach. Interestingly, tomorrow we are running a similar program for our Illinois clients in Chicago, and so we have the deputy governor coming, who's in charge of health policy. So I said, when I was talking to her assistant, I said, now, you guys are going to run an exchange, aren't you? And the answer I got was, we're trying. Side note. Anyway, this is the portion of the program where we invite questions, and if all the speakers would turn on the mics, that you can be heard. I will repeat the questions, and then after we're done with this component, Rob Heath, who's one of my colleagues, will come up and offer a few concluding thoughts. So do I have any questions from the floor for any of our panelists today? I have one that I will start out with. Are employers going to drop insurance for their employees, or do we expect them to continue? Is this the death of employer-sponsored health insurance?
Not in 2014. It may have some impact on smaller employers that are already struggling with costs, and it'll depend on the tipping point for their industry. So if somebody large, like Garden, runs Olive Garden, structures their jobs in a way, or Sears, who says that $5,000 and let them run off to whatever exchange is available. If some large employer set the stage, it's possible that others would follow because of competitive pressure. Most of the employers that we've talked to and larger employers, so I'm not just equipped to answer the question to who's done it. Most of them are definitely not. I don't know of a single company in the local market that's planning to drop coverage and send people to a exchange, whether federal or state. And remember, if you have employees in multiple states, you have to deal with each state you have people in. So with respect to state exchanges, I didn't put those slides up, but there's the difference of whether it's going to be a state exchange, a federal exchange, or a partnership exchange. You have the decisions of whether they're going to do the Medicaid thing. They have the definition of essential health benefits, which can be different state by state by state. So the risk of preemption that large employers have enjoyed is started, and then you're in multiple states. All of that goes away. You're back to dealing with an individual market in every case.
Anyone else on the panel have a perspective on that? Whether employers will drop coverage.
Well, I would agree with Terry. I don't think anything's going to. We see it in the markets that have a lot of hard times with
Second question, how do employers determine who are the employees for which the penalty is payable? How do they determine what employees have gotten on the exchange and taken advantage of the subsidy? Will there be lists?
question, and I'm not sure we really know at this point.
Well, and that's when we talk about guidance not coming, so they always say it's coming.
Go ahead.
If you have less than 50, all of this.
The question is, if you have less than 50, are you exempt from all of this as an employer?
Well, you are exempt from the player. All of these things about the taxes and the plan designs and the exchanges and all of that.
temporary agency employees, is that your personal, or may be full-time at your company, but that you're a temp agency that...
The question was employees of temp agencies.
Okay. As to temporary employees, last year, I think it was, I shared a panel with a woman who directs benefits for Manpower, who was talking about the mini-meds and what they do for their temps and so forth and so on. For Manpower, they're not in a position of even beginning to think about trying to cut their people back below 30 hours, which some of the other employers are thinking about doing in some of the other industries. And this is going to cost them millions to comply with this. But you raise a very good question because there isn't a definition of employee in this law. There's nothing that really talks about co-employment situations, which is what you do when you have a temp agency furnishing you people, and especially if you're doing this with people on a long-term basis, where you really lease all of your people from a particular group in your employment setting that comes through a temp agency. Whose employee are they really? Okay, we really just don't have any guidance on that.
Can I ask a question about the metals, the plans, the platinum, bronze, silver, and gold, I think. Can someone explain, or can one or more of you explain why we need all those different plans and what function that really accomplishes under the Act?
The intent from the proponents of the law, the intent was originally so that it was easier for consumers to shop and compare. There are a myriad of products available from each insurer and from multiple insurers, and the idea was that they could do a true comparison from one plan to the next. And there's been much discussion about what that sacrifices then is the choice for consumers to choose the type of plan that they want. At one point, again, HHS was talking about some flexibility to have those actuarial values be in ranges, so from 59 to 62.5, or from 63 to 65, and you create these ranges. They're starting to pull back on that promise and tighten them back to 60, 70, 80, and 90. In Wisconsin, we thought it was extremely important, if we were going to do an exchange, to have every plan option that's available. Now, that makes it difficult for consumers to shop if they're by themselves and they don't have the advice of an insurance advisor to look at those comparisons. But we didn't think it was right to choice. That's one of the decisions that we'll have to make in Wisconsin as to whether we're preempted from letting our insurers that aren't going to participate in the exchange allow plans to be at 58 or 63 or 72. We believe right now it's our right to allow those insurers to do that, and it's our intention that would be the case, but that's still to be decided. But I think the original goal was that shopping for insurance is too complicated, and we need to make it much easier, give them 4 options.
If the IRS is the enforcer of taxes and penalties, what does that mean for nonprofits?
The question is, if the IRS is the enforcer for tax and penalties, what does that mean for nonprofits? Good question, Amy.
The enforcement still ends up being the IRS because the enforcement of consumers buying their own insurance, whether they're in a group or individual setting, you're still filling out your own tax returns. you'll have to indicate whether or not you have insurance, and I'm assuming there'll be a requirement to show proof that you have insurance, or otherwise that tax penalty will apply to you. As it relates to the corporation themselves, in terms of going after corporations that don't have, nonprofits that don't have a qualified health plan, but they're over 50, they still have, the IRS is still the one to have the ability to, and is tasked with the requirement to find out those that don't and to make sure that they pay that $3,000 or $2,000 penalty, depending on whether the employee qualified for subsidies.
For any mid-sized plans that are self-insured, are there any
That question was for mid-sized self-insureds. Are there any surprises that they need to look out for? Answer was the entire law. Any other questions from the floor or from webinar participants? If I don't see any, I will invite my colleague, Rob Heath, to come up and offer some closing comments here.
Thanks, Tracy. Wow. If you weren't tired when you came in, you certainly aren't by now. This has really been a privilege for us to host this seminar webinar and to begin the long trek that we're all on with respect to the Affordable Care Act. We want to take an opportunity to thank what is a stellar group of individuals here with us today, our panel, who has done, I think, a wonderful job of laying out the challenges ahead, the problems, but also potentially the opportunities. We have now jumped off the healthcare cliff, so to speak. It makes the fiscal cliff look a lot less threatening in some ways. But we're in it together, and we thank Gail and Jerry, Stacy, Kevin, and Dan for their participation, and a very big thank you to Tracy for moderating this and for putting in countless hours planning it and preparing for it. All of your businesses and your healthcare operations and facilities and whatever are important to us. We represent many of you as your counsel, and we want to be available to you as you walk down this road. If you have questions, if you have ideas, if you have challenges that you're facing, we would be privileged to work with you in addressing those and in developing solutions that are compliant with the law, but at the same time hopefully innovative, creative, and beneficial both to your businesses and your employees. That's the challenge that awaits us in the coming years. It's a significant one. We are in a new world. We've left Kansas, and I'm not quite sure exactly where we are, but we're certainly not there. So let us know how we can be helpful. Our contact information is in the materials, and any one of us in our healthcare practice group will be happy to talk with you. We have a dedicated ACO team, and we are ready to work with you to deal with these difficult, interesting, challenging issues. And we will come through it. Hopefully we'll come through it as a nation with a better healthcare system, and in the process, hopefully develop some interesting new approaches to what has always been a challenge, I think, in every nation in this world, and continues to be certainly in our own country. Thank you also to all those who are participating via the webinar. If you have questions or you have issues, please let us know, and let us know how we can be supportive. Godspeed today, and happy holidays coming up. They're upon us very soon. And once we recover, we will have a new year to work on these issues. Thank you so much for being with us today.